Good morning, good morning, good morning. It's Tuesday. It's November 11th. It's Veterans Day. It's all the things. It's all the things. Today we are going to court. I can't wait to go to court with y'all honors. It's been, well, it feels like it's been 100 years since we've been in court, but it hasn't really. It's just been so busy. And of course, it's that time of year where I'm going to be saying that for the next few months, where it's just like, it just is so good to see everybody. And replay crew, don't forget to, check the timestamps down below so you can get to what you want to watch most, fastest, and for the next few weeks, because we're going to just be on a who knows what's happening streaming time-wise. The Law Nerd app at lawnerd.com is 100% where you're going to want to be, because tomorrow we're going to have to change time. Do I know what time yet? No, because I have some other things to hammer out. And then I think I'm going to be traveling, but then again, I don't know if the airlines are going to cooperate with that. So it just is what it is. I was supposed to be traveling last week, and then I was like, traveling is going to be difficult. And then I got sick, and then I was like, you know what? We're not traveling. And then I was glad that I didn't. And then it snowed. I don't know what's happening. It's November. It snowed. It's freezing. Apparently the cold can crack a windshield. Who knew? Tell me you're from California without telling me you're from California. It's every day's an adventure. Every day's an adventure. There are so many, people who do things online and their life looks so glamorous. It's not glamorous here. It's not glamorous here. No, it's not. No, it's just not. It's just what it is. It is mom life. It's 100% what it is. And then we get to come and talk about the thing that we love, which is all of the wild law stuff. We get to come and talk about the law together. It's the happiest part of my day, honestly. So to everyone who is enjoying the sweater weather, enjoy it before it's hot. Again, enjoy fake winter number one. Enjoy the snow flurries. I loved the snow flurries. I was in the car yesterday and I was just like, I like the cold. So I'm just like, I'm ready. I'm ready. And I see a lot of you saying in the chat that you've had heat crack your windshields. I didn't know that was possible. I didn't know that was possible. Oh, Mander Pander said there was probably a tiny chip in the cold. Probably. It's our oldest vehicle. It just happens. It's one of those things where I'm like, that's an adventure that I didn't know we were having this week. Fantastic. Susan said, is your trip to BravoCon? Optimistically. Fingers crossed. Fingers crossed my trip is for BravoCon. And yes, I will post updates. I will post lots of updates. And then in members only, we'll do behind the scenes. However, I gotta be honest with you guys. I do not have the fortitude to do like 5 days in an airport to get to a 3-day event. So if all the flights go sideways, I might just nope out. So I'll keep you posted, because if all the flights are just like, I might also do the same thing and be like, I'll just stay home and snuggle with my cats. So we'll see. We're just fingers crossed. Both cold and heat can crack your window for different reasons. I had no idea. Look, man, you learn something new, and now y'all know. So a lot of you are talking about the airport stuff. It is wild. It's just wild. Travel is so bad right now. No, travel is so bad right now. I'm going to make an attempt. If my flights all get canceled, I am not going to attempt much further. Again, would I love to go to BravoCon? Yes. Do I have things set up to do while I'm there? Yes. Am I ready to do the things? Yes. If that becomes too difficult to travel, am I going to sit in the airport for 15 hours to make it happen? No, I'm not. There will be people who need to travel more than I do, and they can have the seats if the flights get canceled. It will be fine. I would like to go. If it becomes super difficult, we'll just see. It'll work out. We're not going to get stranded. We're going to do the thing or not do the thing. It'll be fine. It'll just be what it'll be. That's my approach at this point. It'll be what it'll be. And then we'll figure it out. So I'm glad that I have the option to do that. And it'll be what it'll be. So there, again, Is it urgent travel for me? No. Would I be sad? Yes. Would we make it work? Sure. Sure we would. I love doing those stories. I love seeing my friends. I'm ready for all the things. I love seeing you guys too. Jeannie said, I met you at a meetup at BravoCon 2 years ago. It was so much fun. That was the last BravoCon because they skipped it this year. So we'll just see. We'll just see what happens. It's going to be fine. I got warm water. We got things. So let's go. Law Nerds today. And I think I said it at the beginning, but for those of you coming in, it is Veterans Day here in the States. So some things will be closed. Some things won't. Most courts are closed. I don't know if all courts are closed. I never know. There's times I'm like, aren't courts closed? And then they're like, nope, not closed today. I'm like, sure. We'll see what happens. But we are going to cover the Bryan Kohberger hearing on delay. It was a few days ago. I haven't watched it yet. We're going to go over the court filings first, and then we will go to the hearing. All of the lawyers appear via Zoom. So we will cover all of the documents that lead up to it and then go from there. And then if we have time, we will see what we have. So for all of our veterans in the audience, thank you for your service. We appreciate you. I saw that Ryan Hall has been, look, whenever Ryan Hall's talking about like exactly where I live, I get nervous. I'm just like, oh, you're talking about me. Because we had some severe weather come through and then we had snow come through. But yeah, it's going to be a snowy winter. It's going to be a snowy winter. And but buckle up, everybody. Look, they're supposed to start doing trial in the Walsh case for December. They're supposed to start jury selection later this month. I don't know if they're going to start or not. We'll see. But yeah, it's going to be a snowy winter. Yep, it is. Dude, if you live in an area where you kind of get snow, but you don't get that much snow, it's time to get the like scrapery doodly boppers and the block heaters and all the things. Just do it now. Because by the time it starts actually snowing, they won't be around. Just do it now. Just do it now. That's it. Do it now. If you don't normally get that much snow, but you're in an area that gets some snow, now's the time. We had our neighbors who had moved from Michigan, which is not an uncommon thing in this area. There's a lot of auto industry in Tennessee, but our neighbors from Michigan bailed us out the first year we were here. They were great. It was so helpful. They're like, for all of you that don't scrape windows, we've got you. Don't worry about it. We've got scrapers. Thanks. We have them now. All right. So today, let's talk about what we're doing today. Today, we are going to cover the documents from the run up to this hearing in the Kohberger case. Then we're going to cover the Kohberger hearing. If you've already seen it, no spoilers. I haven't seen it yet. I know that the attorneys appear via Zoom, but this is all regarding restitution. And for those of you being like, but didn't Bryan Kohberger take a plea deal? He did take a plea deal, and that plea deal involved restitution. And there are a number of motions that we need to go through to take a look at why the conversation about restitution is coming up anew. For those of you who will inevitably ask the intelligent question because the law nerds are bae, you're going to say, but what if he can't pay? If he can't pay, then he can't pay. However, if he has any money come in, if he decides to sell photos from his childhood in connection with an interview, because media doesn't pay for interviews, but they'll pay to use your photos, then that money can go to the Secretary of State. I covered this in another stream and in a podcast episode. That money can go to the Secretary of State and then pay restitution first. So there are ways that any money he has coming in can be redistributed. So we will take a look at the request for restitution. We will take a look at the previous stipulation for restitution, and then we'll take a look at the hearing because the prosecutor was just like, hey, can we have a restitution hearing? And I'm like, y'all stipulated to restitution. What are we doing? I guess we're going to find out. So we're going to go through those documents together. Are you guys ready? Yeah, we're ready. We're ready to do the things. Same. Let's roll the intro and let's get going. Jake from State Farm. Jake in the chat said, did you cover any on the Barista Cup drama? No. I didn't. Is anyone getting sued? If somebody gets sued, send it to me. If they get sued, we'll add it to food court. I was in college when they used to make smoking devices out of the honey ones. So to me, I was looking at it going, isn't that what everybody used to make bongs out of when like we were in college? So it was kind of funny for me, but there was nothing in my world where I was like, you know what, that's what I need. It just wasn't. I don't know. Okay. It's very cute, but I was just like, okay, no. I'm also, if I need to get in line at 4 a.m. to get something, it's going to be concert tickets. That's about all we're lining up for at that hour in the morning. The rest of it is like, if it happens, it happens. If it doesn't, it doesn't. It's fine. It's fine. All right. Let's roll the intro. We've got lots of court to talk about. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. It is time. We have quite a lot of documents on the docket, and if we can get through all of them, maybe we can get to the compendium case from this case. So fingers crossed that we can get to the compendium. If we do, we do. If we don't, we don't. It's just going to depend on time because as I am still planning on BravoCon, I still have all of the like shit that comes with packing for BravoCon, which is not easy for me. Deb in the chat said, me too, Em. First thing I thought was, hey, we use those as bongs. For all of you that are talking about the toilet paper roll or like cutting a roll for paper towels and putting fabric softener at the end of it, yeah, that's a core memory unlocked. That is a core memory unlocked. Yes, because vaping wasn't a thing when we grew up. There were other options. Look at how inventive we all were. We totally figured it out. We were very inventive. There were only so many things we could do. As we look at this stipulation for restitution in the Bryan Kohberger case, you will remember that we were all getting ready for the Bryan Kohberger preliminary hearing. And then it was like, just kidding. We indicted him. And we were all like, wah, wah. What do you mean you indicted him? So no preliminary hearing. So we don't even know, like, boo. Then we were all getting ready for trial and we're like, maybe we'll have some more information about this case. Maybe we'll learn something that we don't already know. And then a plea deal. And we were like, wait, what? A plea deal. And then there was much conversation about what the plea deal was, what it encompassed. There was lots of, I think, misleading information on the internet with people saying that life period didn't mean life without parole. So I think I said about 1 million times, life means life without, like I read the law in Idaho and the law in Idaho is really clear. Life period, no parole. And then we watched the plea hearing together. Then we watched the sentencing hearing together. There are things that Judge H said that still stick with me. And he again struck me as somebody who sent a kid to college. And I was like, ow, this hurt. This whole case just, it's so tragic. It's so sad. It's so frustrating. It is so senseless. It is all of the things. And there were statements that the judge made that just hit. And then there was, sometimes the sadness is harder. The rage is a little easier to tap into. You're just like, yes, rage. And we saw some of that during the sentencing as well. Part of the plea deal was stipulated restitution. After the sentencing hearing, we did not go back and pull those documents. So much more information started coming forward because the judge is going through and unsealing things. Do we have things unsealed in the Reed case yet? No. Are things being unsealed in the Kohberger case? Yes. We'll see it when we see it, I suppose. So a lot of information started getting unsealed. And then there was some information that I was like, I don't know if that some of those photos should have been unsealed, should not have been unsealed. There were some other cases that came out of that to try to keep some photos of victims, which I think is appropriate, sealed photos of the victims in the crime scene and what have you. I have no problem with those things being sealed. I tell you a lot. I'm not a journalist. There were some things I don't have a problem being sealed. Journalists will fight for those things to be unsealed. I am not one. I am not a journalist, and that is not my mission in life. I think it is a plea deal, and there's enough, and we know. So it's going to be fine. And we covered that as well. So let's pull the stipulated restitution, and then we will start going through the other documents that were filed after this. But I think we need to back up, because after the sentencing, I don't know how y'all felt, but I was like, let's just take a step back for a minute. I needed it. I think y'all needed it. We've covered a lot of heavy cases, and some of our lighter cases, honestly, have been on the podcast, and even that, some of those have been quite heavy. So a step back was needed, absolutely needed. So now we are going to take a look back into the world of restitution and what restitution was ordered for the victims' families. And you'll see in the languaging of this, I think that sometimes they will call the victims' families victims as well, because they count under the statute as victims. So when they are talking about victims, just know it as victims/victims' families. And so that's where we are. Emma Max said, can you imagine being in trial for Kohberger right now instead of this mental break? I can't. It was going to be such a long trial. Judge H had set up some pretty good boundaries on how long the court days were going to be. They were going to be shorter court days for Kohberger, but we would still be in trial. Yeah. If not the jury deliberating, we would still be right in that world now. And it would have been incredibly long. And I think some of it probably would have been very dull, as we know in trials. We have those days, but some of it would have been very difficult. And I think the testimony of the surviving roommates would have been very difficult. And I think it would have been a hard case to go through. But with a plea, there is no going through that. And I think that the surviving roommates are probably better for it, even though it is difficult when there was so little known about a case and there remains so little known about a case. And that's hard. No prelim, no trial. So much has been sealed. And there's still stuff that's sealed. When I was pulling up these motions, I'm like, really? It's still sealed? There's still stuff that's sealed. And that's frustrating as well. When it comes to filings in court, there is some stuff, especially after a plea, I'm like, what possibly needs to be sealed about restitution? I mean, other than identifying information which can be redacted, what possibly needs to be sealed? So we'll see. Let's take a look at the docket. This was filed August 27th, 2025, stipulation regarding restitution. The prosecutors are agreeing with the defendant the amount of restitution here, which is going to come up as we look at why is there a restitution hearing if it was stipulated. The Crime Victims Compensation Program, $14,393.13. Jim and Stacy Chapin, $5,720.72. Jeff Kirk Kernodle, $8,843.03 for a total of $28,956.88. Defendant further agrees to pay such restitution with interest at the judgment rate from the date of sentencing by and through the court clerk. So that is the stipulation, the agreed upon restitution. Then, subsequent to that, the prosecution made a motion for a restitution hearing. And we are going to look at the stipulation for a restitution hearing in just a minute. But today is a sponsored stream. And so I'm going to share with you real quick our sponsor, Incogni, before we get into the rest of these documents and then into court itself. So a huge thank you to our sponsor, Incogni, because they let me do the responsible things like play the intro of Queen's music in a live stream. So it's our sponsors that allow us to run the kind of show we want to run around here, and I am incredibly grateful for it. So let's go. Leonard, it's time to talk about your personal data. Every time we talk about today's sponsor, Incogni, there is another massive data breach that we have to talk about. When I saw the headline regarding this Discord leak, I cannot tell you how chilling it was. It wasn't user IDs and passwords. It was government ID photos that Discord uses to age verify its users. The less information that the internet has of your personal identifying information, the better. And that is what I love about Incogni, who I trust to make sure that my information is not all over the internet. They also offer a custom removal feature, which gives you coverage on multiple levels, and something I've not seen offered anywhere else outside of hiring your own attorney to get this done. And Incogni is available risk-free for 30 days. That means you can try it, and if you discover it's not for you, you can get a full refund. So if you are ready to start taking back control of your data, it is time to get Incogni. Use code EmilyDBaker at incogni.com/EmilyDBaker to get an exclusive 60% off. You heard me right. 60% off an annual Incogni plan. That's 60% off an annual Incogni plan when you use code EmilyDBaker at incogni.com/EmilyDBaker. If you've been putting off this type of adulting, now is the time. So let's get back to today's stream. And we're back to today's stream. Emily, your mic. And we're back to today's stream. A huge thank you to our sponsor, Incogni. And they do really keep my information off the internet. It is what I use. So I was really glad that I was not a part of the Discord leak, but I immediately thought of my kids and was digging through to find if their information could have been leaked, because I have them signed up for Incogni as well. We have a family plan. All right, let's take a look at the state's request for restitution. So in August, they agreed to restitution, and the amounts from the victims' families that requested restitution, and I can understand there are times victims' families are like, I want no connection to this person. I do not want their money. I want nothing. Literally, I want them to not exist, and I want nothing. But it can be things like fixed costs, like the cost of funeral expenses and things like that. So let's take a look at what the state is asking for in attempting to reopen the question of restitution after a stipulation, which is unusual to me because they agreed. So everything should already be done. So let's take a look at this filing from September 22nd, 2025, state's request for restitution and motion to seal exhibit. Okay. Comes now the state of Idaho by and through Latah County prosecuting attorney and respectfully moves the court for orders of restitution herein against the defendant and in favor of Steve and Christy Gonsalves in the amount of $20,000 and in favor of Karen Laramie in the amount of $6,920. So the first thing that stands out to me is that these two families were not included in the prior restitution stipulation. In support of this request, the state refers the court and counsel to the documentation appended hereto. 17 pages of whatever that is fucking sealed. Defense counsel has indicated that they will meet with defendant this week to discuss a possible stipulation. The state will advise the court if a restitution hearing is needed, which apparently it was, because they had the restitution hearing, and we're going to watch it together in just a few minutes. The state further moves the court for an order sealing the attached State's Exhibit 1. This motion is based on the grounds that release or disclose would constitute an unwarranted invasion of personal privacy. So I can only imagine that the personal privacy that they are concerned with is the privacy of the victim's family. So I guess we'll see. The defense then objects because, again, there's been a stipulation. I don't blame the defense for that when there's been an agreement. Like, we already stipulated, and the stipulation didn't say further restitution may be requested, further restitution may be required, it doesn't indicate in any way that that stipulation was not complete and total. And sometimes that happens where you stipulate and say, we stipulate to this amount, there is additional restitution coming. Yeah, that happens. So let's take a look at the defense objection to this. The defense is like, well, we object. This is from October 7th, 2025 through the attorneys for Bryan Kohberger, still appointed as attorneys for Bryan Kohberger. Defendant's objection to the state's request for additional restitution. Notice how the defense retitled it. The defense is like, right, they're asking for more. We've already agreed. Comes now Bryan Kohberger buying through his attorneys and objects to the state's request for additional restitution filed September 22nd. The grounds for objection are that 1, the plea agreement specified funeral expenses and funds reimbursed through Idaho Crime Victims Compensation Fund in an amount to be determined within 60 days from July 23rd, 2025. Mr. Kohberger, I don't know what words we're combining there, but there were many. Mr. Kohberger stipulated to those amounts, resulting in court orders in the amount of $28,956.88 on August 29th, 2025. 2, the additional funds sought do not qualify as an economic loss under the Idaho Code because Steve and Christy Gonsalves and Karen Laramie received extensive funds through multiple GoFundMe campaigns that specifically asked for and covered the expenses sought. I'll be interested if that disqualifies the restitution. I don't think that having a GoFundMe would disqualify the restitution. 3, Mr. Kohberger has no ability to pay now or in the future to pay restitution because he is serving 4 consecutive life sentences plus 10 years. That's not going to change anything. Restitution will be ordered and sit on the books in case he comes into money. That part 3 is just, Part 3 is void. Just, we're ignoring part 3. That's not going to fly. Part 2, I'm curious how the law in Idaho will treat that. Part 1 is that they already made this agreement, carries a little bit more weight for me, and I'm curious how we ended up here. Maybe the procedural history will tell us. The defense says a judgment was entered against Defendant Kohberger on July 23rd, 2025. The plea agreement stated, quote, that the state may seek restitution orders regarding funeral expenses and crime victims' compensation reimbursement in an amount to be determined. I remember that from the plea agreement. The judgment of conviction ordered $251,227.50 in criminal fines and fees, footnote 1 and 2. That's not restitution. That's not restitution. That is fines and fees through the state. Different states have different amounts. Some states are much higher. Some states are lower. But a lot of states are like, you've been convicted, pay us back for prosecuting you. We saw that in Florida as well. It goes on to say that $20,000 was ordered as a civil judgment, footnote 3, and they are putting all of these in the footnotes, just listing them out, for each of the families named in the indictment, and also directed the state, quote, to notice restitution for hearing if the parties cannot stipulate to an amount within 60 days, footnote 4. This motion was filed 61 days after the judgment of conviction and commitment filed on July 23rd, 2025. Friends, this is a quadruple homicide that he pled to. A, it shouldn't have been filed on the 61st day. B, that's not going to be the thing that's going to knock this out. The one day is not going to be the thing that knocks this out. If that is the main thing that they are arguing on, The 1 day is not going to be a vibe with this judge. It's just not. It's just not. Then again, maybe it will be. I haven't seen the hearing yet. So, 61st day. Also, the prosecution should have calendared that out to avoid the issue of the 1 day. But I digress. It goes on to say, with respect to the Crime Victims Compensation Program and funeral expenses, the parties so stipulated on August 27th, 2025 to the $28,956 plus. And corresponding orders were entered on August 28th. So if the Crime Victims Fund compensates victims for expenses, then having the defendant reimburse the Crime Victims Fund is appropriate. This was incredibly common in the cases that I handled because most families could not wait until a case was done for things like funeral expenses. They couldn't bear that cost and needed the assistance. And so the Crime Victim Fund pays up front, and then they seek the compensation from the defendants down the road. Not uncommon. So the defense is saying that already happened. And they're saying that on September 22nd, 2025, the state filed its state's request for restitution and motion to seal exhibit, seeking an additional $20,000 for the Gonsalveses and $6,000 plus for Karen Laramie. An itemized statement with receipts was attached under seal. Oh, well, great. Now we know it's under seal. That's helpful. I don't care if we see the receipts. I just wanted to know what it was. Thanks, defense. An itemized statement with receipts was attached under seal. No documentation showing reimbursement by the Crime Victims Compensation Fund was included, footnote 5. Let's look at footnote 5 together. The state produced receipts for earns totaling $1,420 for the Gonsalveses and $1,587 for Laramie. Mr. Kohberger does not disagree that these qualify as a funeral expense, but does request that the court consider all factors and set forth in the Idaho Code. It is really difficult, I would imagine, for families to have to present to the court the cost of the urns for their children. It's just difficult. They go on to say that the receipts relate to travel and accommodation. I imagine that that's then what they're going to fight about, because they agreed to the Crime Victims Compensation Fund, and the stipulation said Crime Victims Compensation Fund and funeral expenses. That's what the stipulation said. The defense is arguing that the receipts relate to travel and accommodation. My immediate first thought is the only reason there was so much in travel and accommodation is because venue was changed at the request of the defense. Going on, the defense says that the plea agreement is unambiguous about the restitution categories. Kohberger agreed to pay, and once receipts and verification were provided, he stipulated accordingly. Quote, and this is quoting from case law, "This court must consider contractual terms that are expressly provided in the plea agreement, as well as those contractual terms that are implied. Given the express language of the plea agreement, the only additional receipts submitted that may fall within the contractual terms are those for the urns. The state has an obligation to stand by the terms of the plea agreement that Kohberger relied upon." So they are saying, look, their travel costs don't fall within funeral expenses and reimbursement to victims' compensation. Linda said, will this all be addressed at the hearing? I sure hope so, because this is setting up what the hearing should be about. Because they asked for a hearing. The prosecution said, we want this amount of money. The defense said, no. And then there's a hearing. So I'm assuming that this is what they talk about at the hearing. I guess we'll find out. No spoilers. Thank you, chat. We're going to watch it together soon. Do not worry. So They've gone back to contract law. Look, this is what we agreed, and stick to the agreement. Economic loss. And then they cite to the code. Idaho Code Section 19-53041A defines economic loss as, but not limited to, the value of property taken, destroyed, broken, or other harmed, lost wages, and direct out-of-pocket losses or expense, such as medical expense resulting from the criminal conduct, but does not include less tangible damage, such as pain, suffering, wrongful death, or emotional distress. Fair. Pain, suffering, wrongful death, and emotional distress are all covered by civil lawsuits. All of those are covered. The direct out-of-pocket expenses, and for any of you that have even been in a car accident, you understand how you're going about your life and all of a sudden you can end up financially upended by medical bills, damage to a vehicle, lost work, especially if the vehicle was the way to get to work. Insurance isn't going to necessarily cover what it will cost to replace your vehicle in any realistic sense of the word. So it is potentially devastating for victims of crime with the damage that can be done just by the life disruption and then the medical costs. It's why there are victim compensation funds. It's one of the reasons when we were going through the Sherry Papini case ages ago, I was just screaming about the amount of money taken from the victims compensation fund by, essentially by her, because it's so needed, because this is so damaging. Even when you're taking a look at things like identity theft cases, the amount of time and money it can take to fix all of that is significant, and it's frustrating. So yeah, of course they had to go to their kids' court dates. Of course they had travel costs. Of course they did. You moved the venue across the fucking state. Linda D asked a great question in the chat. Linda said, is that what Girardi stole from victims' funds? Linda, it's different, but also similar. In criminal cases, when we're talking about victims' funds, the states and counties have victim impact funds that are set up for victims of crime. Girardi was taking from civil plaintiffs that had already gone through their civil claim to claim pain and suffering, lost wages, and all of that. And he was taking those funds, saying that they got less in the civil case. So there's two that are separate. This is coming from the Criminal Victims Compensation Fund, different than the civil fund. But yes, he was taking from his clients. So the defense points out that the code says direct out-of-pocket losses or expense. They go on to say that several GoFundMe campaigns resulted in funds raised for the Gonsalves and Laramie families. I mean, okay, Emily, just keep reading. I'm buffering. I'm going to make myself keep reading, and then I'll say what I'm thinking after I keep reading. We're just going to keep reading, and we'll see. Several GoFundMe campaigns resulted in funds raised for the Gonsalves and Laramie families. Specifically, one GoFundMe campaign for Madison and Kaylee raised $73,000. Those funds were promoted as going to both families, and then they link to GoFundMe. Another GoFundMe campaign for Karen Laramie raised $48,000 to, quote, help Maddie's family attend the Idaho trial, and also clarified that the funds were in fact used to travel to Boise for hearings, including the sentencing. And then it links to the GoFundMe. A third GoFundMe campaign for Steve and Christy Gonsalves raised $85,000 for the purpose of attending court hearings in Boise after the venue changed. And then it links those. Given the specific funds sought and obtained for expenses to travel to Boise, the request should be denied because neither family suffered an economic loss for which the state seeks reimbursement. So they are saying that they didn't have out-of-pocket expenses. They're saying that the code says, an Idaho code says, if they quoted it accurately, and I have no reason to believe they wouldn't, direct out-of-pocket loss and expense. They're trying to argue, because lawyers, that if it's paid by the GoFundMe, it's not a direct out-of-pocket expense. But if they paid it out of their credit card, isn't it a direct out-of-pocket expense? Even if the credit card bill might have been paid through essentially charity or charitable donations, they're trying to argue, it seems, and this is my characterization of their argument. Let me know what you think. But it seems that they're trying to argue that these families are attempting to like double dip and that he shouldn't be on the hook for what was donated by others. Okay. Given the specific funds sought and obtained for expenses to travel to Boise, the request should be denied because neither family suffered an economic loss for that which the state seeks reimbursement. Both families did indicate a desire to refund any donations after the case resolved after sentencing, but whether they were able to accomplish this or donors request funds returned is not included in the state's motion. Footnote 6. Footnote 6 says GoFundMe's policy on returning donations is that once the recipient has received the funds, it's up to the recipient to decide how and whether to return the funds. Okay. I'm going to water. So I see where the technical argument is. I also see where the vibes are. Wait, what? Look, lawyering is not always fun. And making the arguments that are legally proper or might be legally proper, we'll see what the hearing unearths, is the job. Even when the argument might be distasteful. That's the job. And I can see the argument of, are these really direct? How do you define a direct out-of-pocket loss? Is it a loss if it is paid for by someone else? So lawyers are lawyering. I'm not telling you have to like the argument, though. You don't. It can give you the ick all day long. Lawyers are lawyering. That is their job. That is what we want them to do. It is easier to be like, go lawyer, when we like the argument. It's very difficult when the argument is distasteful. But that's not how law doesn't operate. Sometimes it does, but often law does not operate on vibes. So I'm interested to see what the court has to say about this, because what is direct out-of-pocket loss? How would you define it? We'll see what the court says. The next argument is inability to pay. You heard me when we went through this. I'm at a direct miss me on this argument. But they say Idaho Code Section 195304.7 provides guidance in determining whether restitution would be appropriate and states that the court should consider the amount of economic loss sustained, they highlighted that, by the victim as a result of the offense, the financial resources needed and earning ability of the defendant, and other factors the court deems appropriate. They go on to say economic loss is addressed above, and in light of the GoFundMe donations, the specific funds for which the Gonsalves and Laramie seek reimbursement travel to Boise, there is no sustained economic loss. They go on to say additionally, Mr. Kohberger has no ability to earn money. Well, I mean, he may, or pay money given his 4 consecutive life sentences plus 10. He may. I mean, he may. Does he have the internet? He could start an Etsy shop and like sell drawings that he does in prison. Like, he may. You can't say he's never going to. I don't think he should, but someone would buy them. You know that they would. He may. He may have the ability to earn income down the road. So he's also got a lot of time on his hand. So one never knows. He will never earn restitution is kind of a miss for me. It goes on to say, unlike other cases where the Idaho courts have ordered restitution for short and long prison sentences, Kohberger's is different. He will never have the ability to pay restitution, even though he stipulated to restitution amounts. Okay, so then why does it matter? The flip side of that, why does it matter then? Then why does it matter? Why are you fighting then? He'll never have the ability to pay. Then why do you care? If it's all monopoly money anyway, why are we fighting about it? I think it's because it's probably not just monopoly money. Right? Luann asked, is he allowed to sell his side of the story? Yes, he is. Under Idaho law, he is allowed to sell. He is allowed to speak. He is allowed to tell his story. He is allowed to do what he wants. If he makes money from that, it goes to the Secretary of State, and then it repays restitution first, and then anything left over goes to him. So yes, he is allowed to make money, but that money gets diverted to restitution first. This probably, a lot of you are talking about commissary. This probably has to do with commissary. And Avril's Hobby Channel says he might inherit stuff at some point. Also true. He might. So one never knows. They go on to say that he will never have ability to pay, and his case is different. His case is different because it's higher profile. So people will send him money. People will put money on his books. People will want to be his pen pal. People are weird. They go on to say, under Idaho law, he will never be able to profit by way of a book, movie, or entertainment of any kind. That's not true. That's just not how I read the law at all. He is allowed to profit. It just gets diverted. If he has a restitution order of $30,000, $40,000, $50,000 and sells something for $100,000, $50,000 goes to restitution and then he gets the rest. So no, he has the ability to. It just goes to restitution first. The law does not prevent him in Idaho from doing that. Conclusion, for the reasons stated above, Kohberger objects. It goes on to say he waives his own attendance at a hearing on this matter and requests that he not be transported because his defense counsel will be present. Leave me be. Katrin said, is there no Son of Sam law in Idaho? There are not very many Son of Sam laws in the way that you're thinking anywhere because of First Amendment implications. Rando from Iowa said, is the Son of Sam law only for New York? It got overturned in New York. In most jurisdictions that have one, some jurisdictions have nothing, but in the jurisdictions that have one, most of them operate the same way in that the money gets diverted to restitution first, and then the rest of it can go to the defendant. So I did an entire, and I'm sure we'll find it and link it, I did an entire podcast episode breaking that down. The law in Idaho is that he can profit. It goes to restitution first. If there is anything left over, it goes to him. So yes, he can, but it pays restitution first. So the law in Idaho diverts funds. Hopefully that makes sense. And they did that by statute. So let us continue. Schnitt said, wasn't there part of the plea agreement that he can't make money from his crime? No, there was not. The judge advised that he wants him to just not. But that's it. So continuing on, Rando from Idaho said, I'll have to go back and watch that. Thank you. No worries. We did a quick summary, but a lot of appellate work was done in the area of the First Amendment and whether or not a state could say to a defendant, you're not allowed to talk about this, or whether that was an impermissible prior restraint on speech. And we went through some of the different case law, and we went through the way that Idaho has it worded in the statute. So it diverts. Hopefully I think that makes sense. The restitution gets paid back first. It's like having a lien on any future earnings. Does that make sense? Hopefully so. All right. The state responded to the defense before we get to this hearing. So we've got the full breadth of the filings. This one's also pretty short. The state responded on October 24th, 2024. Let's take a look. I made that. I am bigoted too aggressively. Aggressive and bigoting. October 24th, 2025. I think I just said 2024. I don't even know what's happening. State's response to defendant's objections to request for restitution. Notice they're fighting over how to name it. The state said request for restitution. The defense said request for more or additional restitution. Everything the defense does, and whether you agree with their argument or not, everything the defense does is through a lens of advocacy. And since the beginning of this case, Ann Taylor has been very focused on that. She has, sorry, we needed more lippy. She has very mindfully languaged things in a way that they are all filtered through a lens of advocacy. And she does that consistently. So, the state respectfully responds to the, quote, defendant's objection to the state's request for additional restitution filed October 7th, and the state acknowledges. What is the state acknowledging? The state acknowledges the Rule 11 plea agreement filed herein regarding restitution under Section 4 of the agreement states. The state may seek restitution orders regarding funeral expenses and crime victim compensation reimbursement in an amount to be determined. At the time of the plea agreement, the state was under the impression, that's not a good sentence. The state was under the impression certain expenses incurred by the victims' families would be covered by the crime victims' compensation. After the sentencing hearing, the state was informed that crime victims' compensation will not cover travel and lodging expenses for attendance of court proceedings. Well, that explains why they languaged, maybe overconfidently, languaged the plea agreement the way that they did. They languaged the plea agreement because they believed that the families would be covered by crime victims' compensation, and then crime victims' compensation would be compensated. Who was the state informed by? The state was informed that crime victims' compensation will not cover travel and lodging expenses. Why did you think that they would? Why were you under that impression then? Also, if it's unclear in any way, do you know what would have cleared this up? Funeral expenses, crime victim compensation, and any court-related expenses. Another sentence would have cleared this up. And he would have agreed to it. One more sentence in the plea agreement, and it would have been fine. So the state said funeral expenses and crime victims compensation, thinking that crime victims compensation would take care of all of this. And then after the sentencing, it was like, oh, whoopsie. How do you not know? You're the elected prosecutor. Does this never come up? You know what? To be fair, maybe it doesn't. When you're in Moscow it probably doesn't come up because no one has to travel to court because things aren't moved to the other side of the state. It really probably doesn't come up that often, if I'm being generous. But wouldn't you ask about this? But maybe it was we looked at it, it will be fine. The plea agreement happened incredibly quickly. But because the plea agreement happened incredibly quickly, it would have been reasonable to have been broader in the stipulation for restitution to allow room for shit like this to happen. Well, that's a problem. Because crime victims' compensation didn't cover it. After sentencing, the state was informed that crime victims' compensation will not cover travel. Notice that the state say they were under the impression. Why are they under the impression? They go on to say, on behalf of the victims, the state submits an itemization of expenses that were incurred by the victim's family, including expenses not covered by the crime victim's compensation for the court's consideration. But the plea agreement says funeral cost and crime victim's compensation, and this is not funeral cost. And this is not crime victim compensation. It would have, I think, been covered under the law. The law says expenses. If they had put another line in the agreement that said expenses, it would have been in there. But if the crime victims compensation fund doesn't cover it, and you agreed to funds that are covered by crime victims compensation, well, I understand the argument about the agreement and this being outside of the agreement. So the prosecution fucked it up, is what it looks like. But the statute allows for it. The agreement just needed one more, literally 4 more words. And they had to have known how much money that the family spent traveling. 4 more words. It goes on to say, on behalf of the victims, the state submits an itemization of expenses that were incurred by the victim's family. A lot of you are asking in the chat, why doesn't this count as compensation? When I'm reading this saying crime victims compensation, we are talking about what that particular fund that's administered by the state covers. We're not talking about what the law and the statute allows. We're talking about what that fund covers. So we're not talking about the colloquial, well, isn't this compensation to crime victims? We're talking about a specific fund that is administered, and the fund says, but we do not cover expenses in this way. We do not cover travel and lodging. But it seems that the prosecutor shorthanded, well, anything that the CVC covers needs to be reimbursed. And after the plea, the CVC is like, well, we don't cover that. And I imagine that no one knew this at the time of plea and sentencing. And it was probably a surprise to them later. Sounds like it was a surprise to the prosecution. I imagine that this didn't endear the prosecutors to the families any further. The families that were already mad were probably like, well, yeah, of course, what else did we fucking expect? They go on to say that the state is affirmatively advocating for payment of funeral expenses as itemized by State's Exhibit 2 pursuant to the plea agreement. The defendant argues that the requisite or the requested restitution should not qualify as direct economic loss. I think it counts as direct economic loss, but the words direct economic loss aren't in the agreement. The defendant argues that the requested restitution should not qualify as direct economic loss since the victim's families received third-party donations. Under Idaho Code 195304, and controlling precedent, directly injured victims may receive full restitution despite third-party payments unless those third parties qualify as statutory victims through contractual obligations to pay. So like insurance, which happens all the time in vehicular homicides and such. If insurance pays for it, insurance gets recompensated, so it does not double dip. And then the insurance is the quote unquote victim who gets paid on that. That is not uncommon either. That's not the circumstance here. But it's nice to know that the law accounts for this. So from a 2007 case, State versus Cheney, the Cheney analysis to this case, charitable donations such as those received through GoFundMe arise from voluntary generosity rather than legal obligations. Legal obligations, e.g., just think of this in the context of like a car accident. You get in a car accident, somebody hits a vehicle, the driver that hits the vehicle is doing something that causes them to be charged with a crime. Be it DUI, be it reckless driving, whatever it is, they get charged with a crime. Insurance pays for all the stuff for the injured victim. Insurance can then go after the victim's compensation fund and go after the defendant to be recompensated for that through criminal restitution instead of going through civil, or both. They can go through both. So it really just depends. But that is the contractual obligation, e.g. insurance. This is not a contractual obligation. This is charitable donations. Wherever you get that charitable donation from, it's not an obligation. And it sounds like that has been contemplated by this case from 2007. The prosecution argues, therefore, their payments, so the charitable donation payments, the payments from from GoFundMe, don't qualify as statutory obligations, and the payments don't reduce the defendant's obligation to restitution to directly injured victims. That extends to family, as we talked about at the beginning of this. This is also supported by public policy consideration, focusing on making victims of crime whole for a defendant's criminal conduct rather than accounting for a victim's good fortune in receiving community support. And I could understand if the law was, hey, if you get GoFundMe money, then the defendant doesn't have to pay. The people would be like, yeah, but fuck that guy. Like, I want them to be helped, but also I don't want him to be off the hook because people were generous. That would not work well, I would think. If people want to be generous, they want to be generous, right? Sorry, there was a smudge on my screen that I'm looking at trying to read this document to y'all that I imagine was placed there by Fred. It's not slander, it's true. And it was making me crazy. I'm cleaning you off. I can see better. I can see clearly now. It goes on to say that the defendant argues that restitution should not be awarded based on the defendant's, quote, ability to earn money or pay money given his 4 consecutive life sentences plus 10. Idaho 1953-04 provides clear authority for courts to order restitution from life sentence defendants. The statute mandates, shall. The statute mandates that courts shall order a defendant found guilty of any crime which results in an economic loss to the victim to make restitution to the victim unless, and I think that's either worded weird or I worded it weird in my brain, unless the court determines restitution would be inappropriate or undesirable. I don't think that's the case here. It goes on to say the immediate ability to pay restitution shall not be in and of itself a reason to deny restitution. State versus Baby. I have no idea. Bybbee. We're going with that. While Idaho law permits restitution orders for life sentence defendants, courts retain discretion to determine whether restitution is appropriate in individual cases. What do you think Judge H feels about this case? I'm with you. It goes on to say this discretion enables the court to consider the specific circumstances of life sentence cases, including the defendant's age, health, and realistic earning potential. In this case, there's a history of the defendant receiving financial compensation from family and third parties. Tell me everything. Excuse me, Bill Thompson, tell me everything. You're not off the hook for fucking that up on what gets paid for and what doesn't, but if you'll spill the tea, at least we have the tea. I mean, that's something. He says, by way of example, the state is attaching a summary of the financial contributions made to defendant while he was in custody at Ada County Jail and the Latah County Jail. In the event defendant is able to obtain financial compensation from third parties or families, the victim should have ready access to the assets for the satisfaction of their losses. Yeah, you can't just hide money on your books and then, say it's all going to beef sticks. It can get diverted for restitution. And I'm not mad about that. Are you? Let me know. If you're just like, well, yeah, that's money people are donating to him. It's just like the GoFundMe. Let me know what you think. If people are putting a bunch of money on his books, I think it can get diverted. I don't think all of it should be diverted, but I think it should be substantially diverted. I don't know. What's a fair percentage? 60-40? 50-50? 80-20? You let me know. What's a fair amount to divert? I mean, YouTube takes 30% of all earnings. It's got to be over 30%. I will stand for nothing less than 30%. It's got to be more than that. We're not going 90-10. Oh, unless the 90-10's the other way. I wouldn't be mad by that either. But 80-20, I mean, fair. Some of you are saying 100%. Some of you are like 70-30, 75%, 90-10. Yeah. Becky RN says, how many honey buns can a person eat? Are they vegan? Is he still vegan? I don't even know. I was making beef stick jokes, but I think he's also vegan. I have no idea if I don't know. I don't pay that much attention to whatever he's doing in custody. But I will always make beef stick jokes about custody. The last person I heard talking about them regularly was Alec Murdaugh. Maybe a fake vegan beef stick. Okay. So he goes on to say that Kohberger was receiving financial contributions while in custody. And if he's receiving those compensation or those funds, the victims should be able to have some of that money diverted to them. It goes on to say, additionally, this case has and will continue to attract worldwide attention and could result in the defendant prospectively receiving monies subject to interception by the state treasurer. Right. Diversion. I mean, interception, diversion, whatever you want to call it, stick to the code. It will be intercepted. Restitution orders may be recorded as civil judgments and should be collectible from any monies prospectively deposited into escrow with the state treasurer. Based on the above, the state requests the funds. Fair. So I think it is time for us to get to court. Miguelina, will you do me a favor and let the app know that we are going to the court hearing now? And if anybody is like, we want to know, we are going to court now, because I think now it's time for us to go to court. You know what we didn't do? We didn't fly to Idaho. So let me pull up this hearing real quick and make sure we have it on the big screen and with the ability to gain up the audio. That would be helpful. We need to do that. I'll pull it up on the big screen and then we will fly to Idaho together. I think that is a fair way to do it. Did I pull it up before? No. The last time I prepped everything in advance, I had too many tabs open. Shit got crashy. And YouTube's been squirrely enough. I don't need everything to be squirrely. We need something to not be squirrely. Let's make sure we have closed captioning on. And let's fly to Idaho, shall we? I think we shall. Let's go. No delays on ADB Air because it's magical. Tell me what snacks you're having. Let's go. All right. Let us go to court. How's that sound? Oh, this is I've got multiple tabs open. Well, damn it. I was like, how does that sound? Wrong tab, Emily. Wrong tab. Let's zoom till everybody starts fussing and we can hear that. The UI is different on YouTube on my larger screen. All right. How's it sound? How's it sound, y'all? Other than paper shuffling. Pretty loud to me. There's a lot of Judge H paper shuffling. I mean, now I just want to know what pen it is. That pen just was like, it was ready to go. I'm gonna actually, Emily, grab your notes because I will forget to grab my notes and then I'll want them and then I'll be mad. So, all right. I have my notes because otherwise I will not be able to recap very well. It'll be terrible of me. So let's super note it up. Looks like we got all the attorneys. Bill Thompson is sitting in the dark with the window light to get him by. Everybody else has the unfriendly overhead lighting. Y'all, there are really little
lights. Let's go on the record in State v. Kohberger, CR 012431-665.
Give me that. Dude, I am just trying to grab the closed captioning. The whole screen was just like, nope. No, we're not.
The defendant has been excused from today's proceedings. It is not present. The defense is represented by Ms. Massoth, Ms. Taylor, and Ms. Barlow. The state is represented by Mr. Thompson. This is a time set for a hearing on the state's supplemental request for restitution. The state can argue first.
I love that JH is just like, tell me why we're here. Let's just get into it. Amy's booklet list says, does EDB air charge baggage fees? No. Does emotional baggage count? You're welcome to bring it with you, but also if you want to just leave it at the airport and pretend it doesn't exist, we're with you because EDB air is magical. So we get to do whatever we want. So no, your luggage will just magically appear where it is. So you don't have to wheel it through the airport. If I had my way, we'd just teletransport it. It'd be great.
Thank you, Your Honor.
All right, Bill, explain yourself.
The attached documentation, it doesn't appear that there's...
Why does it sound like somebody's in their fucking car? Also, first, what the fuck? Second, how did we get here?
A question about the amounts. I think the question that has been raised is whether the propriety of any additional restitution being ordered at this point. Yesterday afternoon, we did receive a supplemental filing from the defense, and I want to respond to that just for the record before I address the merits of the restitution requests themselves. As we indicated in our response to the defense objection to the additional restitution request, at the time that we entered into the plea agreement, Ms. Jennings and I were under the impression that crime victims' compensation could be available to cover.
Right now, we are listening to the prosecutor argue. For those of you newer to the case, no worries. We are listening to the prosecutor argue. The other attorneys are the defense attorneys, but we are listening to the prosecutor argue. Also, no matter how much you explain to me that you're the one who fucked up, that's really on you, not the defense. The state gets held to their agreements. That's on you, dude. Like, what are we doing? Ugh.
Before I address the merits of the restitution requests themselves. As we indicated in our response to the defense objection to the additional restitution request, at the time that we entered into the plea agreement, Ms. Jennings and I were under the impression that crime victims' compensation could be available to cover reimbursement of travel expenses. And I have to clarify that now. It is true that before trial, the families approached our office asking if there were any resources we were available to pay in advance for travel expenses or expenses related to them attending trial itself. And we looked into that, our staff looked into that, and advised them no. It was my understanding, and I'm mistaken, I realized I was mistaken at this point, but it was my understanding back in early July, late June, when we were talking about the plea agreement, that crime victims compensation could be available to reimburse expenses like that. I now know that's not correct.
So he said, we knew that we couldn't pay the expenses, but we thought we could reimburse the expenses once they paid for it. But can you imagine thinking, okay, I mean, these families were looking at potentially months in hotels at their own expense and missing work. It's just a wild potential amount of money, or like a 3-month Airbnb or whatever it is. And he's like, so we thought that they could reimburse, and we're wrong. It might not be something that comes up that often, because this is all because of the change of venue. This isn't normally going to happen, though the circumstance here is unique because these are college kids. And so their families might not all live within Idaho, depending. So it's unique, but it's not that unheard of. I'm sure that prosecutors in Vegas are well aware of all of this because, you know, when you live in a travel destination, stuff's going to happen. And then the defendants and the victims might all be from out of state visiting. So it sounds like it doesn't come up that much for him, but that's on him. And he's going on to explain that they were wrong. I'm curious to hear the explanation.
And I realized I was mistaken at this point, but it was my understanding back in early July, late June, when we were talking about the plea agreement, that crime victims compensation could be available to reimburse expenses like that. I now know that's not correct, and it was certainly my mistake. I will own it as far as our state of mind going into.
So are you going to pay it? Like, are you going to pay it then?
The plea agreement. So that being said,
go ahead.
I'm sorry.
Go ahead. I'll let you finish the point on the plea agreement, and then I have a question for you about that.
And I was just finishing that point, Your Honor, so this would be a good time.
Okay. So it's pretty well settled that plea agreements are interpreted as contracts, which they are. I think it's pretty well settled contract law that a unilateral mistake does not relieve one of its contractual obligations and restrictions. So how can I enforce?
Right.
How can I order this restitution if the express terms of the plea agreement, though mistaken understanding by the state, don't allow such extra crime victims compensation fund reimbursement?
And Your Honor, I recognize that, and that's what I was just getting ready to address. In response to the defense's objection, the state has modified or adjusted our position on the restitution. We are, pursuant to the plea agreement, seeking restitution for the funeral-related expenses, which are the urns that are described in Exhibit 2.
So they were originally seeking, hold on, I'm going to pull this back up. Just so we're clear on the change. They were originally seeking more than $20,000 for the Gonsalves family and more than $6,000 for Karen Laramie. And under $2,000 per family is for the urns, which are the funeral expenses. So are you telling me that you have now gone from asking for $20,000 to asking for just under $2,000 for each family? Because it sounds like that's what's happening. All right, let's get back to this hearing. It sounds like that's what's happening. All right, back to hearing. I should swoop. Because it sounds like what he's saying is, yeah, we fucked up and we didn't include it in the restitution. And the person who suffers with that are the families. All right, back to court.
To our response, we are not affirmatively advocating for the travel expenses and lodging expenses of the family because we do not believe that we can legally advocate for those. At the same time, the families provided those to us and we want to provide them to the court and counsel just so everybody was aware that they are there, but we are not arguing affirmatively for that because of the
Your
wording
mistake
of the plea agreement itself.
No. Because of your mistake. Because of your mistake. Drama Llama Mama, I'm going to hold your question. It's a good question. I'm going to get to it after we hear court. But it's not because of the wording of the plea agreement. It's because of the way you worded the plea agreement. You could have added in travel expenses. They didn't. They shortcut the way that they wrote it in. This is frustrating. I am frustrated with you. Thank you for name calling, y'all. I get it when what you say in the chat is, I want to call names. I understand. I am with you. I also fill in the blank in my head. Thank you for not name calling. I am frustrated with this. You fucked up. That's not a good fuck up. I don't like it at all. I'm mad with you. You are all welcome to be like, I am mad. I am mad too. I'm mad. I don't like it. I don't like it at all.
What the state is actually requesting today is just additional restitution for the funeral-related expenses, which are the earns for the families.
Okay, thank you. Then you can address the other issues as well.
I'm sorry, Your Honor, which other issues?
Well, the issues.
I'm surprised the defense doesn't just say, excuse me, Your Honor, just to save us all some time, we stipulate. We stipulate. The earns were under $2,000 per family. We stipulate to the additional, $3,500 or whatever it is. We agree. Can we all go back to lunch now? Are we done? Because when you take the travel expenses out of it, the cost of the earns was low in comparison.
If you would like raised in opposition to your motion, including the lack of ability to pay by defendant and et cetera.
Yes, thank you, Your Honor. I apologize. The defendants.
The court is asking the prosecution to address the defense's other objections, e.g. he can't pay and the rest of it. So that's what they're getting into now.
Has raised the issue of his alleged inability to pay, and we recognize that he's going to be incarcerated until he dies. But that in and of itself doesn't mean that over the course of the balance of his life, he might become...
He has time.
He might receive assets. And in fact, we attached a breakdown of the types of monies that he has received during his incarceration. We also noted the statute that allows the treasurer to intercept prospective monies that might be received based on any attempted publication of the story of the defendant. And those, if received, would be something that a restitution order could be enforced against. We also note that the language of the statute and the case law interpreting the restitution statute, which is 1953-04.
I agree with him on this.
Off the top of my head, talks about current inability to pay is not necessarily a block to the order of restitution. It's just merely a factor for the court to consider. And it is our position, given the relative youth of the defendant, the fact that he has been receiving significant monies during his incarceration already, and that there is the possibility of future monies, whether by virtue of the statute with the treasurer impounding proceeds from a story related to this, or perhaps from an inheritance from his family or others. We can't see into the future. We don't have a perfect crystal ball. The state's position is having the...
You don't seem to have any form of a fucking crystal ball because you thought that the way that you wrote the plea agreement was going to be fine, and it wasn't. So yeah.
this additional restitution place, which is really fairly minimal, would be appropriate, and have them available that if the defendant comes into assets, that the families would be able to try to satisfy the restitution orders from them.
Thank you. And then who's arguing for defense?
I will be, Your Honor.
All right.
All right, that's Eliza.
Thank you. Given that the
Massoff.
state has clarified its position that it's only seeking reimbursement for the earns, it's my understanding that that amount is $1,420 for one family, $1,587.79, and then another $167.79, which would be a total, I believe, if my math is right, of $3,075.58.
Right.
My understanding of reading the Victims' Compensation Code 1953-04 is that the court must still do an analysis on Mr. Kohberger's ability to pay. And as
You stipulated to funeral expenses. An urn counts as funeral expenses. You agreed to funeral expenses. Why are you now trying to argue over ability to pay? Just stop it right now. The state had to walk back all of what they were asking for. It's time to just stop it. There's a lot of this hearing left. What are we doing? You stipulated.
the state has addressed, we are arguing that he does not have an ability to pay. While there have been lump sums provided to you regarding some funds that he received prior to his plea agreement, what the court does not have is a breakdown of how those funds came into the inmate system for his expenses and the fact that they were primarily family. Certainly his situation pre-plea and sentencing was drastically different than it is right now in terms of money that is available to him. And there's nothing in the record to provide the court with anything other than what is really speculation based on the past, as opposed to something that the court might be able to rely upon about.
Your Honor, grab it from the prisons. Hey, just grab it from the prisons. Find out how much money he's got. Let's do it. Do it. Your Honor, do it. I want to know. Just now's the time, Your Honor. Now's the time.
Mention it all.
Now's the time.
Mention it all.
Find the money. Go get it. Go get it.
Foreseeability. There's no way that Mr. Kohberger is ever going to profit from any sort of movie or book because Idaho Code 1953-01 specifically precludes that.
Well,
Don't think that does.
It.
That is not what I interpret the law to be. I'm going to let the judge interpret it, though. Me, not an Idaho attorney. I'm not going to interpret it for the court. We already talked about it earlier, but I don't agree with the defense's take on that. Looks like the judge is in the same place I am because we were like, that's not what that says. It's not what that says.
Specifically precludes that.
Well,
and
precludes, it allows that monies are swept from his account
Yes.
For those income to pay certain things.
Yes.
If those certain things, if there's no debt for those certain things, then
He gets
does
it.
the money not go then to the defendant?
Yes, it does.
that is
Yes, it does. Yes, it does, counsel. Stop looking like a goldfish over there. Yes, it does. Yes, it does. Yes, it does. If there's $50,000 in restitution ordered and a defendant makes $100,000, the $50,000 in restitution gets paid, the balance of it goes to the defendant. Yes, it does. There's no well, actually. Doesn't the remainder just go to him? Yes. And she's sitting there going, well,
if those certain things, if there's no debt for those certain things, then does the money not go then to the defendant?
That is not my reading of the code. Perhaps I'm reading that statute more broadly than the court is. I understood it.
Ma'am. The statute's really fucking clear.
To be that the purpose is that someone can't then profit off of their
That's
crime,
not what it says.
pursuant to that statute.
Wrong.
I guess I need to read it with.
Well, even
I read the case law too. I researched this to do a whole podcast on it because y'all asked so many great questions about it. And I was like, you know what? Let us learn. And it is very clear that it is like paying a lien. Compensation gets paid first to the victim's compensation fund, to any restitution ordered. All of that gets paid first. If there's anything left, it goes to the defendant. It does not stop them from making money unless there's more restitution than money. But if there's more money than restitution, then yeah. Once it's paid off, they get it.
One can't then profit off of their crime pursuant to.
I
that
backed it up because I
statute.
was
guess I
yelling.
need to read it with.
well, even
that broad
even allowing your
implication.
even allowing your reading of it, what's to prevent, for example, a family member from agreeing to, provide information, be a part of, et cetera, a story, movie, book, whatever, TV series about the murders, about Mr. Kohberger, and
Giving him that money.
That certainly wouldn't be monies they receive wouldn't be subject to the statute, and then they certainly would be free to send Mr. Kohberger money
Yep.
to his account. What harm is it to order the restitution, which would then sort of jump in line in terms of priority of payments over some of the other?
Jump in the line, Your Honor? Your Honor? You are correct. Beetlejuice is going to get stuck in my head real fast. All of it.
Ordered payments, such that if Mr. Kohberger does receive money into his accounts from any source, that he's then that those monies are then put to that use. Certainly, we're not worried about Mr. Kohberger's credit rating with having debts at this point. I'm not sure what the concern would be to, given the uniqueness of this case and the potential for family members, et cetera, to earn money from it, and potentially we've seen members of the public send money to Mr. Kohberger, is my understanding, to his books.
The judge is like, why does it matter? Then why does it matter? Then why does it matter? This is restitution. He agreed to restitution. Put it in there. And I think they should be able to take the books. I agree with you, Your Honor.
What's the downside to ensuring that the victims are as whole as possible from this by ordering the restitution, which again would jump in line from some of the other court-ordered fines, et cetera? And if the money's there, it's there. If it's not, it's not.
Exactly.
Judge,
Yep, Judge H, I agree. Emily agrees. Exactly. Just do that. Hearing adjourned.
If it's not, it's not.
Judge, I don't see that Idaho Code or Idaho law asks the court to make an analysis on the downside, but whether or not there is foreseeability of payment. And all of the things that you just listed are pure speculation. There is no book or movie that's in the works by any of his family. And to say that those things are going to happen is absolutely speculative, and there's nothing to substantiate those sorts of assertions happening in the future. So
No.
There's a history in the 3 years
Nope.
he was incarcerated of him receiving 5 figures put on his books.
What did you say? What did you say? That's not speculation. 5 figures? That's not speculation. That's money on the books. That is money in the bank, as it were. Oh, tell me more about the money, Your Honor.
Mention it all. Mention it all.
Before the sentencing, 5 figures onto his books. So tens of thousands onto his books.
So
There's a history in the 3 years he was incarcerated of him receiving 5 figures put on his books. Doesn't that give the court some history
Yes.
to suggest that such contributions from whatever source may continue into the future?
It does. Yes, it
as I stated earlier, Judge, that was at a different time in the case. That was at a time when, he had not entered a plea. He was not deemed convicted of the crime. The money.
What, the girlies on the internet stopped sending money after the plea deal? I doubt that.
A lot of that money was coming from his family to be able to have communications
Not all.
with their son and brother, and to.
What did you just say, counsel? A lot of that money was so they could have communications with him. What, he wasn't going to talk to them unless they put money on his books? Stop it. Also, he can message them collect. You don't need to put money on the books for that, counsel.
Crime, the money, a lot of that money was coming from his family to be able to have communications with their son and brother, and to speculate that those types of dollars are going to be able to happen for the next many decades is exactly that. It's pure speculation, not based on something that is foreseeable or based in something.
Oh, I think it's foreseeable.
In fact, before this court.
Well, it just seems to me that one of the, really, obviously, even application of statute requires the court to look at what might happen into the future. And I guess, it seems to me one of the best indicators of the future
past.
is the past. And in the past, his family has, you're saying the family was the source of much of these funds, has provided him funds in order for him to communicate, et cetera. That necessity will still exist going forward. I'm not aware of his family having disowned him at this point and not wanting any contact with him. And even if they are, that doesn't mean that won't change. And you call it speculation. It seems to me that it is good evidence of what may occur in the future in light of what has occurred in the past.
Well, Judge, there is a judgment against him in the amount of $28,000, and certainly 20% of every dollar that goes into his inmate account is going to go towards paying that $28,000.
Well, there we go. Thank you, counsel. We've all learned something. 20% of his books go towards paying restitution. Well, that's good to know. There's the answer. I think it could probably be more. But 20% goes to paying restitution. Fine. If people keep putting money on his books, his restitution's gonna get paid. If people are putting tens of thousands of dollars on his books, Idaho, I think you could probably do more than that. I mean, at least like match the tax rate or something. I think you could do more than that, Idaho. I really think you could. But I'm not mad. At least it's something. Look, I'll take 20% over 0%. I'll take 50% over 20%. I will. I'll take 50% over 20%. But I'll take 20% over 0%. So, all right. So money that goes to his books, now that there's a restitution order, money that goes to his books will have at least 20% siphoned off to pay the restitution orders first. And the restitution orders will get paid in order. So the restitution orders will get paid to the victims' families first. then to the state restitution funds, then to court fees and fines. So families first, then the victim compensation or victim restitution fund, then court fees and fines. Okay. Let's continue on.
Of $28,000, and certainly 20% of every dollar that goes into his inmate account is going to go towards paying that $28,000. Another factor that the court actually can look at under 1953-04 subsection 7 is other factors, and those factors that
we've learned today.
Factors that the court deems appropriate, and that can be collateral resources that the families obtained over $200,000, which
you're arguing collateral resources from the GoFundMe for their murdered children when the state has already said all they're seeking is the compensation on the earns? No, that's counsel, you're not looking at the judge's face while you're making this argument. Look at the judge's face. Counsel, look at the judge's face. This was an argument to just, once the prosecution backed off of all of the amount of money, this was an argument you just scratch off the list. Just scratch it off the list. Just get rid of this one. Just I'm excited to see what the judge's face is going to continue to do.
Definitely reimburse the cost of the earns in terms of
the GoFundMe has reimbursed the cost of the earns. I'm backing up to let her continue to make her argument without me interrupting.
The other factors that the court deems appropriate, and that can be collateral resources that the families obtained over $200,000, which definitely reimburse the cost of the earns in terms of economic costs.
I also want to turn to the plea agreement because isn't a
the court's like, yeah, no, yeah, no. Let's go to the plea agreement. That squarely falls within funeral expenses. Squarely within funeral expenses.
a reasonable interpretation of the plea agreement that the defendant will not contest the state's seeking of restitution that is outlined in the plea agreement. Otherwise, why would it need to be in the plea agreement? It seems to me it's the plea agreement. A reasonable interpretation is the defendant is agreeing to pay restitution for those items that are identified in the plea agreement, which includes victims' compensation. Which includes in this case funeral expenses.
The judge is like, but isn't part of your plea agreement that you're not going to fight this, counsel? You're treading on some dangerous ground, counsel. Because if part of the plea agreement is that you will not contest it, you trying to violate your plea agreement? Counsel, I don't think that's what you want to do. Nah, I don't think that's where you want to go at all, counsel. That's not great. The judge is like, let me remind you what the find out part is.
So you took advantage of the plea agreement to get the benefit of the bargain regarding the state's dropping of the death penalty. Mm-hmm. Why should you not be held to the plea agreement to pay the victims the costs of interning their children?
Judge, I believe that our pleading was clear, that we understood that burns fell underneath a funeral cost.
Then why are you fighting about it? Then why are you fighting about it right now? The judge is like, this clearly counts. Why are you arguing?
That once we have a hearing on this matter, that doesn't eliminate the court's duty under 1953-04 to do the ability to pay analysis. And that's why.
Well, are you in violation?
You agreed to fucking pay. You agreed to pay. The prosecution came in and asked for stuff that was outside of the plea deal. And the prosecution came into this hearing and went, our bad. I hate that too, but our bad. At that point, the defense should have said, hey, if they're withdrawing the things that we don't think fall under the plea agreement and just talking about the earns fall under the plea agreement. We have nothing else to say about that, Your Honor. Instead, she's saying, no, we agreed to pay restitution, but now the court has to make a further determination. No, the fuck they don't. No, they don't. No, they don't. Ooh, counsel, you're in danger. But the judge is I'm kind of living for the judge at the moment, so I'm going to let him go. I'm going to back up because I want to hear it all. But oh, no, she didn't. No, she didn't. No, she didn't.
Respect my authority!
Counsel's trying to make a that's my opinion argument, and it's not going to go well. Oh, the judge is going to be so mad.
It's the plea agreement. A reasonable interpretation is the defendant is agreeing to pay restitution for those items that are identified in the plea agreement, which includes victims' compensation, which includes in this case funeral expenses. So you took advantage of the plea agreement to get the benefit of the bargain regarding the state's dropping of the death penalty. Why should you not be held to the plea agreement to pay the victims the costs of interning their children?
Judge, I believe that our pleading was clear, that we understood that burns fell underneath a funeral cost, but that once we have a hearing on this matter, that doesn't eliminate the court's duty under 1953-04 to do the ability to pay analysis.
Disagree.
And that's why.
Well, are you in violation of the plea agreement by arguing that your client shouldn't have to pay those?
Oh boy.
We are not in violation of the plea agreement. If there was any violation of the plea agreement that took place, it's the state seeking this when the other expenses, when it was clear under statute and under the Idaho Victims Compensation rules that those were not reimbursable expenses.
Oh boy.
But they've effectively withdrawn those requests and are seeking what's outlined in the plea agreement. What's the point of the plea agreement on restitution if the defense is able to argue against the restitution called for in the plea agreement itself?
Judge, again, in our pleading, we objected to what the state has withdrawn as of this moment.
You're still arguing it. Chat motion granted. Have you ever argued with someone and you're like, why are you arguing with me? And they're like, I'm not arguing with you. I agree with you. We're not arguing that, but you still have to make a determination. Dude, why are you arguing? We're not arguing. Yes, you are. Yes, you are arguing. And the court's like, what are you doing? Well, we're not arguing. Yeah, you are. You're still arguing. You agreed to pay restitution. The court does not need to make a finding. The beginning of this hearing, when the state said, we fucked up, the court should have said, bro, how? But we fucked up. We're only asking for the earns. The defense should have said, we agree to the amount of the earns. They are covered under the plea agreement. We don't need to address anything further. If the state is withdrawing that, we don't need to make any further argument. But that's not what they're going to do, is it? No, they're going to make further argument. And the chat has been making the motion for code red for the last few minutes, and that motion is granted. For those of you that may be new to my channel, welcome. If you are sensitive to flashing, code red is a bit flashy, but it ends when the music ends. And I agree. We're going to code red. We're going to code red. This trial would have been exhausting. This is a 20-minute hearing. This trial would have been exhausting. But I agree with you. It's like a code red. It's like all of it. So we're going to code red. In 3, 2, 1. We read. Let's go back to court. Because what are you doing? The court's like, but you're arguing it now. I'm not arguing, but you're doing it now. You're doing it presently. Oh my goodness. Let's continue.
And at this hearing today,
Right.
we acknowledge that the earns were funeral expenses.
Right.
But once we're in this situation of having a hearing, then this other section about whether or not he has an ability to pay is triggered. We stipulated to $28,000 in restitution.
It's not a good argument.
Within 60 days.
Right.
He met the terms of the plea agreement.
But it also says the state may seek restitution regarding funeral expenses, and they're
Right.
simply identifying additional funeral expenses.
Right. Yep.
I
What the
don't
judge
know
said.
what more you want me to say about the earns other than
What's
they
the point
are-
of the plea?
He wants you to fucking agree, counsel. What are you looking at? Why aren't you looking at text messages from Ann Taylor going, danger, danger, danger. Stop. Why aren't you looking at your text messages? He wants you to stop. I don't know what else you want me to say, Your Honor. Stop. Just stop. He wants you to stop. Well, actually, Your Honor, once there's a hearing, we have the opportunity to argue it. No, you don't. That's what the judge is saying. Just because there's a hearing doesn't mean you get to open this up for argument. It's not open for argument. And the court's saying, you making it open for argument, is that you violating your plea agreement? The court has given you every hint in the world, not subtle, every hint in the world that he is not pleased with this chain of argument. The court is not happy. Your Honor, we would agree with the earns. If the state is withdrawing the other amounts, then there is nothing more for us to say. Sit down. But you're already sat, so then you just stop. However, I'm kind of loving the court fighting with her, so I'm just going to back it up because it's been a minute since we've been in court. So we're going to back it up and watch it happen again because the court's not having any of it, and I kind of love it when the court's not having any of it. So a lot of you are asking, can Ann Taylor intervene? Ann should be texting counsel. Just stop. Because if they were in court together, she could lean over and be like, it's okay, just the earns, it's fine. We agreed to that. But she's still arguing.
drawn as of this moment at this
I
hearing
backed up a little.
today.
Right.
We acknowledge that the earns were funeral expenses.
Stop arguing.
Right.
But once we're in this situation of
Wrong.
having a hearing, then this other section about whether or not he has an ability to pay is triggered. We stipulated to $28,000 in restitution within 60 days.
Right.
He met the terms of the plea agreement.
But it also says the state may seek restitution regarding funeral expenses, and they're simply identifying additional funeral expenses.
I don't know what more you want me to say about the earns other than
What's
they
the point
are-
of the plea agreement if you're not going to
I
be
laid
bound
out
by
the-
it?
I agreed that it was $3,075.58.
But you say you just shouldn't have to pay it.
What I said was that the court needs to do the analysis under Idaho code
This is not helping counsel.
about his ability to pay.
Why
He doesn't
hasn't the defendant waived his right to rely on that ability to pay by agreeing to those expenses as part of the plea agreement?
Yes.
I don't know how the court can enter this order today without engaging in the analysis under Idaho code because it's required. That's the way I review the case law and the code.
You stipulated it's not required. The judge looks like he is actually trying to physically hold in words. The judge looks like he is trying to hold it in with his face. He's just like trying to hold in all of the words.
That once there's a hearing about restitution, then the court has to engage in the
Ma'am,
analysis. on the
look at
ability to pay.
your screen.
So
You need to look at the
agreement
judge.
to pay is illusory.
Oh shit.
No, he agreed to $28,000.
Oh, the judge is so mad.
Then the court has to engage in the analysis on the ability to pay.
So the agreement to pay is illusory.
Wow.
No, he agreed to $28,000. We've agreed that earns fall underneath.
Does he have the ability to pay that?
Expense. No, he does not have the ability.
So
to
why
pay
did you
that.
agree to it?
Because it was a specific, we were provided with those receipts within 60 days. We were not provided with the receipt for the earns within 60 days.
So is your objection then a timeliness objection?
She didn't
We
say
did
that
raise a timeliness objection
in a footnote.
in our pleading. I have thought about that and whether or not I think that it is a really valid argument to say that that's completely jurisdictional. I didn't to mean that the court can't take this under the review at this point in time. I didn't read the judgment language in such a strict fashion that I felt like we could say 61 days means the court's not going to consider it at all. So it is past your 60-day deadline, but I don't know that that is completely jurisdictional.
It's 1 day past the 60 days in the agreement. This is not a point to fight on. I understand why she would want to fight on the other amounts. This is not the thing to fight on. And the court is asking her, but you agreed. You agreed. You agreed. And she's like, well, now the court has to go through this analysis. He's like, no, I don't. It's a stipulation. Why do I have to go through the analysis? There's no analysis to go through. At this point, she just is fighting with the judge for absolutely no purpose. And the judge is like, let's ride then. Let's go. Let's go. Because he's not having any of it at all. This is not the battle to fight. Yikes.
Fictional in the way that you drafted your judgment.
Anything else?
No.
Thank you. Mr. Thompson, any rebuttal?
No, Your Honor. Thank you.
All right, thank you. I'll take the matter under.
Santa read the room. Santa's like, nope. Nope. I have nothing else to say.
Advisement and issue an opinion in due course.
Did you see how fast she logged off of that Zoom call? Look at this. Look at this.
All right, thank you. I'll take the matter under advisement and issue an opinion in due course.
Could not log out faster. Just immediately gone. Boop. Gone. Wow. That was ill-advised, counsel. That was ill-advised. So let's talk about the hearing in Idaho from November 5th. The prosecution asked for additional restitution and then started the hearing with, we are withdrawing our request for everything except the amount of the earns. The restitution agreement is very specific. It says funeral expenses and things that were reimbursed by the state victim compensation fund, essentially. And the travel expenses, the prosecutor said, we found out after the plea that those would not be compensated. So under the way we wrote the plea agreement, we can't ask for that. So the prosecution is saying that is completely our bad. We messed up on that. That was not our understanding. We thought we had it right. We didn't. It could have been fixed at the plea agreement. And the court said, but I can't fix it now because you made an agreement and you're being held to that agreement. And the prosecution said, you're absolutely right. We're only asking for the earns. And then the defense, instead of saying, we agree to the earns, we didn't agree to the rest, it was withdrawn, we have nothing more to say, the defense decided to continue arguing that the court needed to make a finding that the defendant should be required to pay the restitution. And the court was not having it at all. The court said, but you agreed. You took the benefit of the bargain. If we're looking at contract law, and you argued contract law, if we're looking at contract law, the benefit of the bargain is that the death penalty came off the table. You agreed to pay restitution. This is just another category of appropriate restitution for funeral expenses. Why are you arguing? And the defense said, well, we still need the court to make a determination that it's appropriate restitution. And the defendant has the ability to pay the restitution. And the court's like, are you violating your plea agreement in making this argument? And the defense said, no, I'm not violating the plea agreement. The prosecution was violating the plea agreement by even asking for those additional amounts. And the court said, bro, I'm summarizing, bruh. They withdrew it and admitted that that was their error. And yet you're still arguing. Here we are with the arguing. The court was not happy with the defense arguments about Kohberger's ability to pay and whether this was appropriate and whether the court should order Kohberger to pay the restitution, which the court is clearly inclined to do. My only question is how much, but the court is clearly inclined to order Kohberger to pay for the urns for the additional victims that were not put in the agreement before. So when we get to the end of the day on this, I think that the court is going to say these additional funds are getting paid. You're going to pay them. And that he has the ability to pay, but kind of spilled the tea on some of the stuff that was under seal as attachments in these arguments, which was how much the defendant had put on his books. And the court said he has had at least 5 figures worth of money, over $10,000, so potentially tens of thousands of dollars, put onto his books during the time that he was pending trial. And the defense was arguing, but that's changed now that he's pled. It's a different situation. A lot of that money was from family, and it's a different situation now. He doesn't have the ability to pay. And the defense argued he can't earn money from selling his story or talking about this case or anything like that. And the court said, no, I disagree. I do not think that that's what the statute said. I agree with the court's interpretation. The interpretation of the statute in Idaho regarding whether defendants can essentially profit from discussing the crimes that they are convicted of is that the money gets diverted to pay back restitution and restitution judgments first. And then any money that is left over, if any, goes to the defendant. It's not that they can't earn it. It's that it pays off restitution before they get it. And what we learned from the defense attorney, which answered a question that I had, was that 20% of any monies put onto the defendant's books do get diverted to start paying those restitution orders so that the restitution will get paid to the victims first, then to the Crime Victims Compensation Fund, then to the court orders. So that 20% will make sure that the victims get paid first. It might be slow, but if he lives a long life in prison, then they might see that they get compensated for what has been ordered, which is funeral expenses, and then reimbursement to the Victims Compensation Fund. Now, if the victim's family chooses to fight with the State Victims Compensation Fund, I don't know if that's going to be like trying to fight with insurance to cover something they say they're not covering. I don't know. I don't know if the families will choose to say to the Victim Compensation Fund, no, we were told you would reimburse our travel expenses, reimburse our travel expenses. They might choose not to do that because it does seem that they received money from GoFundMe's. That money shouldn't make the defendant off the hook for restitution. But the way that the prosecution wrote the restitution order cuts out all of those travel expenses. But that's on the error of the prosecution, not because of GoFundMe amounts received. And the court was very much like, hey, be mindful of these arguments. Because are you going to violate your plea agreement? And the prosecution did not say, well, the defense is violating their plea agreement. You should withdraw the plea agreement, Your Honor. I don't think the prosecution's going to argue that. I don't think they want to gear this case back up for trial because if the defendant violates their plea agreement, it just turns around and it all goes to trial. And that's not what the court asked for. That's not what the prosecution asked for. But the judge warned the defense pretty sternly that you're treading into some potentially uncomfortable territory here. Knock it off. So let's answer your questions. Let me go take a look and see if the judge's order is in. The last time I looked at this, I did not see it. I saw the judge's orders sealing the declarations, but that's it. There is no order from the court in yet. If the court order comes in while I'm traveling for BravoCon, assuming that planes are doing the things, I'll let you know in the Lawnerd app. I'll just tell you in the Lawnerd app because that's it. I'll let you know in the Lawnerd app. James asked, if you can't pay it, why fight it? I don't know. I think the defense had a legal point as to the error made by the prosecution. They have a point that travel expenses do not fall into the two categories they agreed to pay. That's an error on the part of the prosecution. But as to the earns, I don't know why they were fighting it at all. It was wild. So why she kept fighting over something they're not fighting about is bananas to me. So frustrating. It's really frustrating to be watching the argument from the outside going, counsel, are you so used to fighting with judges that you're just fighting for the purpose of fighting? It felt like counsel was not listening to the court and was going to say what she was going to say no matter what. And as the court was getting more and more and more frustrated, it doesn't seem like counsel clocked it at all. Like, period. That was frustrating. That was really frustrating to watch because it was so avoidable. However, Judge Hippler does not mince words, and I appreciate that about him. He has been really direct throughout this case, and from everything we've seen, he does stick to the letter of the law. The letter of the law is not in the defense favor on the arguments they were making today. What time is it? Chat, I'm going to put up a poll. We're going to put up a poll. We're going to answer some questions. Well, let's answer some questions. And then, here, let me type it in. Let me type it in. And then we're going to answer some questions. And then we'll see if we have a little bit more time. Let's see. We did talk about crystal balls today. All right, I'm putting a poll in. Let's go to Q&A real quick. And then if we have time, maybe we will add in another topic. Jenny D, I didn't interpret it that way. Jenny is saying in the chat, they said he paid the $28,000 already. They said that he did not have the ability to pay it, but they agreed to it. So they said he doesn't have the ability to pay that, but they had already agreed to that amount. So that's where we're at on that. Let's get the lights back where they need to go. And let's go to questions real quick because we got to get out of the code red. The questions are not fuckery. They're just good questions because the law nerds are bae. A number of you have said, no, I heard that too, that they said he'd already paid the 28. He had already agreed to the 28,000. No worries. Jenny, I'm glad you cleared it up because a lot of people were on the same page you were. It's a good question. She said he does not have the ability to pay that, but he did agree to the 28,000. And the court was saying, okay, but he agreed to the 28,000. What's the difference of adding like the 3,000-ish for the earns? Like you already agreed. So the court was kind of throwing the defense's argument back at her by saying, okay, well, you already agreed to the 28,000. Are you telling me he can pay that? Then because you're fighting this saying he can't pay, but you agreed to that. Are you saying he can pay that? She goes, no, we're saying he can't pay that, but we did agree to it. So that's when the judge asked. Jem Babe said, right, that's when the judge asked if it were illusionary. Yes, illusory. That's when the judge said, so what are we doing? We're just playing pretend? For sure. So let's get to a few questions and some chats. And then 86% of you are like, yeah, TikTok psychic updates. And then we can get to some updates on the TikTok psychic defamation case. For those of you that are like, girl, what are you talking about? It is the Idaho defamation case from a TikToker that accused another party of committing the murders in Idaho, not Bryan Kohberger, and it's getting ready to go to trial. But the court already found on summary judgment that the TikTok creator is liable for defamation, so they're only going to trial on the damages. But the TikToker is representing themselves. So that's where we're at. Christine D and many in the chat said grateful for our veterans today. It is Veterans Day. Happy Veterans Day is not the right thing. It's just how to acknowledge it without saying, happy veteran. In acknowledgement of Veterans Day, y'all let me know. Ben Aaron in the chat asked me to read a meme. I am not from Baltimore. He said, but say Aaron Iron earns. I am not from Baltimore. It's less funny when it's me. Silver Mom said, question, if he finds they are violating the agreement, could this lead to larger consequences? We could. Sarah in the chat said, in Canada, we say lest we forget. That is much better. Honoring Veterans Day, lest we forget, in remembrance of Veterans Day. I like that in Europe, it's Remembrance Day. I do. And I like that in the UK, you see people wearing the poppies. Makes it easier. But either way, it is. Sarah in the chat said, you can say Happy Veterans Day, but do not say Happy Memorial Day. It is fair because for our veterans, I hope they are well. So raise a glass for Veterans Day. I like that. We're there honoring. We remember. Thank you, chat. I appreciate it. So with that, Silver Mom asked, if he finds they are violating the agreement, could this lead to larger consequences? If the court finds that Kohberger violates his agreement, the court could, in theory, hear me when I say in theory, this is not happening. In theory, the court could withdraw the plea agreement and make this go to trial with the death penalty still on the table. That's not going to happen. The court's not going to do that. The prosecution's not asking for that. That is not going to happen. But if he violates his agreement, that could happen and it could nullify the agreement. I don't think that's happening at this point. I don't think the judge wants that. I don't think the prosecution wants that. I don't think the witnesses wants that. I don't think anybody wants that. So it is just, I don't think anyone wants that. Botanist Gaming said code red plus code bra equals code bread. On food court days, 100%. I mean, today it's like, we're not even baked. Today is cooked. So, JDG said, take the W and walk away. I mean, the defense really could have graciously said, if the prosecution is, or even if they wanted to be snarky, they could say, if the prosecution is withdrawing their inappropriate ask, we agree that those are proper expenses. They could have been snarky and still done it. Just interesting choices. Casey Cat asked in the chat, EDB, couldn't them fighting restitution nullify his plea agreement and put the death penalty back on the table? In theory, I don't think anyone wants that to be the result. I don't think the court wants that to be the result, but I think the court was mad. So the court being like, girl, what? I think that was the way of the court trying to get the defense attorney to be like, girl, what? Girl, what? Declan said motion for an EDB Airbnb in a pocket dimension so we can access it anywhere we want, anywhere we are for in court and anywhere we want. I mean, granted, if I could make it happen, I absolutely would. If I could do it virtually, I would too. So we have like our own little virtual lounge space. I'm working on it. I'm working on more virtual lounge spaces to roll out with the lounge. But yes, it would be a pocket dimension would be amazing. It would be great. I'm here for it. Shannon Johnston in the chat said, teaching my 3-year-old toddler who's on the spectrum to say I am mad versus throwing things or hitting. So I felt that. There are times where I have to still remind myself, because I am a foot stomper. I have slammed a door in my day. I do not with the kids because it stresses everybody out. But there are times where you just are just like mad, need to move the mad. And so I do. There are times my kids are looking at me and I'm like, no, I'm mad. It has nothing to do with any of you. I need to go for a walk. 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 Because it helps. We also have a punching bag upstairs, which really helps. The punching bag is great. The punching bag is helpful for all. But need to go for a walk. But sometimes just being able to say I'm mad is incredibly helpful. Cause mad. Priya said, why can't the state pay it or pay out? I don't know what the rules are for how the Victims' Compensation Fund is managed, what it pays for, what it doesn't pay for. But there are rules, and it will, like insurance, it will pay out within the rules, but it will only pay out with the rules. And so there is that. Drama Llama Mama, I said I was going to come back to this in the chat and said, can the family sue for ineffective counsel? No. The prosecutors aren't their counsel. The prosecution represents the people of the state, not the victims' families. They're kind of stuck with being frustrated, and I imagine at one point being given the information that this would be compensated in the form of reimbursement. And so I imagine they're incredibly frustrated, but no, they can't. They can try to appeal, I guess, the denial of the reimbursement to the Victim Restitution Fund. I don't know if they will choose to do that. If the GoFundMe covered it, the families may choose to leave those funds for other victims' families that do not have GoFundMes and the like. But if I was the families and that's going to be recompensated by Kohberger, I'd be like, hell yeah, take 20% of his commissary for the rest of his life. If that is the only inconvenience we can cause him, then fine. That is the only inconvenience we could cause him. But go ahead and put it in where he has to pay it. So if he's getting money from people on the internet or his family or whatever, then yeah, he should have to pay it. And he will have to pay those funds. So I can understand if they chose to go after Kohberger for it, but did not choose to go after the compensation fund for it. Does that make sense? So Gail B asked, why just 20%? I don't know how the rules were chosen in the state of Idaho. So I don't know. So could the families civilly sue? Rebecca, they could civilly sue. I don't know if they will choose to or not choose to. They could. That's between them and their civil lawyers. They really might want to be done with him. They might not want to be locked in litigation with him and keeping his name in the news for another 5 years. And then civil litigation, even when you win, it just appeals. Civil litigation takes forever. They might really just want to close this book, not even the chapter. They might just want to close the book on it and move on as best they can, because grief is not linear and is a difficult journey. Staying locked into, there might be a ruling, we have to do this, we have to do that, really might keep them in a place that they don't want to be. So could they make that choice? Yes. I don't know how long they have to make that choice in Idaho, but they could make that choice. It is really up to them. Grammy Pammy, me too. Grammy Pammy said, I go for a drive with the windows up and scream at the top of my lungs. I am a scream singer. Yes. Yes, 100%. So we are there. Robin says, lots of prayers as my 17-year-old is learning to drive. Lots of prayers and motion sick bands, and it will be good. Look, it will be good. It will be good. There are things you probably don't need to know about, and that will be fine. It's fine. It's very fine. And There have been times where I've had Travis run errands and it's been delightful. It's like, hey, on your way home from school, can you pick these things up? Oh, it's so helpful. It's really nice sometimes to have another driver in the house. And so having him run errands for gas money has been fantastic. And he does a great job at it. Jory Johnson said, love getting to be a part of the live. I love having you here. I love seeing you guys. It's fantastic. Celtic Moon said, snowy here in Syracuse making soup. Sounds delicious. Sounds delicious. Chronic Shock said, waved my mom off to the Caribbean this morning with my laundered luggage tag. It will travel vicariously through my parents for me. She loved the quality. I love them too. I love the merch that we create for the Launards. It is one of my favorite things. It is a labor of love, but it is one of my favorite things. We are always working on bringing you excellent things and making sure that they get to you easily in a cost-effective way. Monuments of Speculation, thank you for the gifted membership. Welcome new members. We will be doing some member stuff. We have a couple members things that we will be doing this month, and we will 100% be sharing behind the scenes if we make it to BravoCon. If we don't, I'll let you know. Miss B. Haven asked if this was my replacement mug. This is my like hot watery mug, or bigger coffee mug. But yes, it's one of them. But this one I've had for a minute. I did get a replacement of my beloved dragon mug. So I have one of those too. J. Michael, friend. A, member for 50 months. B, congratulations on your oncology board. I am sure that the Lawnards have celebrated much. It's always so good to see you in the chat. I am sure that Jade has celebrated with you. Congratulations. Hold on. We need the kids. We need the kids to clap. Where do we put our claps? Hold on.
We need the clapping. I'm trying. We're trying to clap on and clap off here. Where did it go?
Congratulations. Under Your Scars said a plea is being broken, ? The court told them to tread lightly. They sure did. Ann Bell said, happy Veterans Day is fine. Veterans Day is for the living. Memorial Day is for those that gave their last full measure in service. Yes, it still feels, it's heavy, but I'm here for it. I'm here. And when the veterans say it's fine, I'm taking it. Tina said, thank you for your service, which works, I think, maybe better. All right. Are we ready? And I love this. I find a visit to the local rage room where they have stuff I can break and they clean it up as great therapy. The problem is I have not been doing archery nearly as much, which was really my favorite outlet for all of this. Archery is just perfect. But I have not had nearly enough time, which is a goal in the coming year, to make sure to have more time. More time is needed. So it is a goal in the coming year to have time for the hobbies and to continue to make time for the hobbies because I miss it. I mean, it counts as a workout. It's archery. It's hard. You guys voted. 84% of you are like, TikTok psychic, let's go. I think we should do a quick TikTok psychic update. Like, it's not enough information to do a whole episode. I think we just do a quick little TikTok psychic here. We should probably do a quick road so far for those of you that don't know this case. If you don't know this case, just go ahead and put a 1 in the chat, and I will modify how long and or short my update is based on that. So let's get to it. All right. TikTok psychic defamation case. A TikTok creator got sued by a University of Idaho professor over defamation. The TikTok creator said repeatedly that the professor was involved in an inappropriate student relationship, inappropriate because professor student, so in an inappropriate student relationship. And because they were trying to cover up that relationship, commissioned the murder of that victim and the roommates. The creator is representing themselves. This is in federal court in Idaho. It went through motions for summary judgment. The court granted the motion for summary judgment on the ultimate issue of liability, finding that the TikTok creator, in fact, defamed the professor. This is pending trial in the beginning of the year on damages. The creator is still representing themselves. The professor is not representing themselves, is represented by an attorney who we have seen in the other case because it is the same attorney, Attorney Olson, who represented the media coalition in the Kohberger prosecution. Now, the creator has tried to say, well, I believe it. The creator has tried to say, well, prove that you didn't murder, which is not the standard. So come prove that you didn't. And then the creator made a motion. This was the last thing that we talked about. The creator made a motion with regard to the expert witnesses for the plaintiff. And then we have seen objections to those and nothing else. Well, we need to keep in mind this scheduling deadline and the fact that I foresee this going badly. I do not think that the TikToker is going to show up for trial. The TikToker does not live in Idaho. I would be really surprised, really surprised if the TikToker shows up in Idaho. Like, really surprised. And I think the court's aware that they're not going to show up. Let's take a look at the scheduling order to refresh our recollection, and then we're going to take a look at what's been filed, because a bunch of dates have come and gone. Oh, I mentioned this is in federal court, right? Federal judges are so patient. But I think the court's going to probably end up issuing a default judgment. I don't think this is going to go to trial. But let's see. All right, order setting trial. The court has resolved all the motions to date. Discovery is closed. The case is ready for trial. Trial date. A 4-day jury trial is set for Tuesday, February 24th, 2026, beginning at 9 a.m. Pacific in Coeur d'Alene, Idaho. Footnote 1. Plaintiff's complaint was brought in Moscow, Idaho, and demanded a jury trial. There is no longer a federal courthouse in Moscow, Idaho. Therefore, unless ordered by the court or agreed by the parties, the trial will take place in Coeur d'Alene. Remember what happened? The TikToker said, well, I agree that it can take place in Texas. The court was just like, no, it's not. Lyndon, you make an excellent point. Lyndon said Idaho may have rules for trial in absentia. They might. I need to look. They might say, hey, fine. The other party's not here. Prove it to the jury and let the jury find an amount. They might. So the trial is set to take place Tuesday, February 24th, starting at 9 a.m. Pacific. I appreciate, because there's multiple time zones in Idaho. Apparently there's 14 states in the U.S. We were talking about this on a road trip over the weekend. There are 14 states in the U.S. that have multiple time zones. Things you talk about, wonderful. Things you talk about when you're driving from one time zone to the other. And every time you do, you go, oh, wait a second, right? Because Californian, I could drive 5-6 plus hours in any given direction and still be in the same time zone. I'm in Tennessee and I'm like, we've only driven like 2.5 hours. Why are we in Eastern time? What is happening? I'm so confused. When I try to do things, I'm like, shit, I need to plan extra time because the time will change. Apple Maps actually does a really good job of planning your drive. If you put like arrive at a certain time, it will adjust for the time zone change, because I will forget and it will mess up my life, because we're never planning to be anywhere an hour early. Let's be real. The court ordered that the trial will constitute 2 15-minute breaks, 1 hour lunch, and will end at 5 p.m. The court's like 9 to 5, 2 15-minute breaks and a 1 hour lunch. That's it. On day 2, the court will follow a compressed day, which will begin at 8:30 a.m. and end at 3 with 2 15-minute breaks, no lunch. Pretrial conference date. A pretrial conference is scheduled to take place at 10 a.m. Mountain Time on February 5th. Yes, I have this date in my calendar. Yes, I am going to request phone access to this pretrial conference to see if the TikToker shows up 100%. To discuss and resolve insofar possible 1, legal issues remaining, 2, evidentiary issues, 3, trial logistics, including exhibitees and witness lists, and 4, any other matters. On or before January 29th, 2026, the parties shall communicate and reach an agreement on as many items as possible, including stipulations related to the parties' proposed exhibits. This should include stipulations on foundation or other evidentiary matters, even if there is a disagreement as to whether a document should be admitted based on relevancy issues. The parties shall be prepared to discuss with the court those items over which counsel and parties disagree. The pretrial conference will be held via Zoom. Counsel and party to receive the video link via a separate notification. A second in-person, underline bold, a second in-person pretrial conference is scheduled to take place at 10 a.m. Pacific on February 23rd, 2026. You think that's going to happen? Daubert motions should be filed by September 2nd. Responses September 16th. Any Rule 702 motion shall be filed by September 23rd. Witness list should be filed by October 7th. Exhibit list and exhibits should be filed by October 7th. By February 16th, the week before trial, counsel and party, representing themselves, shall provide the court with copy of exhibits in electronic form. And then the court goes through how to do that and how to number them. Jury instructions shall be to the court by October 7th. Proposed voir dire, October 7th. Trial brief, October 14th. Motions in limine, October 14th. Responses to motions in limine, October 21st. Replies to those motions, October 28th. And then they go through trial procedures. Anybody want to guess? Anybody want to guess what was filed by the TikToker? Go ahead and put your guess in the chat. At the end, it says the parties are ordered to notify the court on or before January 30th, 2026, if the case is settled or will definitely go to trial. Chat remains undefeated. Absolutely nothing. Absolutely nothing. The TikToker has filed nothing. They filed the Daubert motion with regard to the experts, and we went through that motion together. But since then, absolutely silence. Nothing from the TikToker. Now, the plaintiff, the professor's lawyer, has filed all of the things that they were supposed to file, including their trial brief and a motion in limine. We're going to look at those real quick. They're not extensive, and we're going to just touch on those. I don't know if the TikToker is even going to show up to the next hearings. Has not responded to all of these. All the dates have passed. Like, all of the dates are done. So, the October 13th motion in limine from the plaintiff. Introduction. The court has already determined that defendant, TikToker, defamed plaintiff professor when TikToker published online numerous false statements asserting that the professor had an affair with a student and then orchestrated the murder of 4 students to cover up the affair. The only issue left for trial is the amount of damages professor should be awarded. Yet, TikToker's past conduct suggests she will use trial as a platform to make a mockery of the murders by continuing to make her outrageous and baseless statements about professor. I don't think she's going to do that. I think she's not going to show up. I really don't. I don't think she's going to show up. That's kind of where I'm at. If she does show up, that's dead ass what's going to happen. Like 100%. I don't know if she's going to show up. It goes on to say, given the court's decision on summary judgment, any efforts by TikToker to present the quote unquote truth of her defamatory statement are irrelevant to the issues to be tried. 100%. Artsy Talulu said she's going to, quote, be there in spirit. 10 out of 10. Martha said what happens if she doesn't show up? Well, they could do the trial completely without her, or they could issue a default judgment where the court says, okay, she didn't show up. So damages are, you're asking for damages in this amount. Here's damages in this amount. We're not wasting a jury's time with this. There you go. Or they could order her to come to court, find her in contempt, and then fine her every day she doesn't show up. I don't know if they'll do that. Danita said, who pays for all this nonsense? Unfortunately, the professor. The professor pays for this because it's a civil case. So, but the issue of liability's been determined. It's just a matter of damages. So they might just enter an award of damages based on a presentation by plaintiff. Plaintiff says, I'm asking for this. And the court goes, okay, done. She didn't show up. We're granting you damages. We're not wasting a jury's time. We'll see. Accordingly, the court should enter an order prohibiting TikToker from presenting any evidence or argument related to the quote unquote truth of whether the professor had an affair with a victim or orchestrated the murders. Background: as the court well knows, this case arises out of the tragic murder of 4 University of Idaho students. Following the murders, TikToker published hundreds of videos online about the professor. Then they go through the legal standard, and then the argument is, quote, TikToker has made a spectacle of the tragic and brutal murders of 4 young students at the University of Idaho to gain attention for herself on the internet. We know that that particular sentence really pisses off the TikToker. She takes issue to it in every filing. It goes on to say, while TikToker's content started on TikTok, she has regularly used these proceedings as a platform to make additional outrageous and false statements about the victims and the professor, all without a shred of evidentiary support. The upcoming trial is only about the amount of damages to award the professor. This trial is not about whether TikToker's statements about professor are true. The court has already held that they are not. Correct. Nonetheless, TikToker's past conduct suggests it is likely she will try to use trial to repeat her baseless assertions that the professor had an affair with one of the victims and orchestrated the murders to cover up the affair. Any evidence or argument to that effect has no bearing on the facts to be determined on trial, and even if it did, any probative value would be far outweighed by the danger of confusing the issues, misleading the jury, etc. As a result, the quote evidence or argument is inadmissible under Federal Rules of Evidence 402 and 403. TikToker should not be afforded at trial any more opportunities to harm professor or disrespect the 4 victims. Accordingly, the court should enter an order prohibiting any evidence or argument related to the false assertion that there is any truth to the statements. Agreed. Agreed. 100% agreed. Cena, aka Potato Supreme, asked about punitive damages. Yes, the court allowed punitive damages to be added here. So they might ask for a trial in absentia to allow the jury to just whack up that number of punitive damages and be like, no, this is fuck you behavior. Here's fuck you punitive damages. They might. And the court might allow that too. We'll have to wait and see. The professor also filed a trial brief. Let's take a look at that real quick. And then we're all up to date because, well, TikToker's been real quiet in filings. Stephanie said, has the TikToker uploaded anything new? They lost their account on TikTok, and I have not tried to find them elsewhere on the internet because I just don't want to know. Wait, Rando from Iowa, what? Rando from Iowa in the chat said, is she one of the psychics that told Kim K she would pass the bar? Okay, first of all, we talked about Kim K and the bar a little bit in the podcast on Monday. I don't know about Kim K and the psychics. I'm curious. But also, did the psychic say first time? Because she may pass the bar eventually. Was it specific? Because sometimes the universe is just like, I mean, it'll happen. We didn't say it would happen right now. So, you know, we'll see. But I'll have to go look for that because the ChatGPT stuff sent me. We're going to need a whole ChatGPT lawyer situation. Let's take a look at this trial brief, shall we? October 13th, 2025, plaintiff's trial brief. We know the background of this. Defendant TikToker, a resident of Texas who has never even been to Idaho, took the tragedy in Moscow and the hysteria surrounding it as an opportunity to garner attention for herself online. A clout circus, as it would seem. All right? Relying on tarot cards as well as her quote-unquote spiritual practice and quote-unquote psychic abilities, TikToker posted over 100 TikTok videos about her quote findings related to the murders. Much of her content focused on her conclusion that a professor at the university, had an ongoing affair with a student and then orchestrated the 4 murders to cover up the affair with that student victim. The post went viral. She had over 100,000 followers on TikTok, and some of her videos had 2.5 million likes. I imagine the view count on those were quite high. TikToker's statements about Professor were false. Professor had never even met any of the victims, let alone had an affair with one or participated in the murders. And after the professor filed her complaint, Kohberger was arrested. Remember, the complaint that it wasn't me came before Kohberger was even arrested. But they go on to say TikToker's statements on the internet, particularly before the public knew and accepted that Kohberger was the murderer, had consequences in the real world. At the time when the smallest, quote, clue could rile up the public who were upset by but knew very little about the murders, the professor feared for her physical safety of herself and her family. If someone tried to seek vigilante justice, this fear led to economic losses as the professor needed to pursue a security system, but the fear also had an emotional toll, causing her to suffer from PTSD and incurring financial damages for treatment. The professor also suffered damage to her professional brand as a teacher and academic. When students, publishers, potential collaborators on research, potential attendees of a talk or conference search the professor's name online, they see content of her alleged affair with a student or role in the murders that distract from her many accomplishments as a teacher and academic. Professor did not want to litigate the case, sent TikToker to cease and desist. TikToker used as a prop. Yeah, and made content out of them, pretending they were toilet paper in one of her TikTok videos. Left with no other way to get the TikToker to shut the fuck up. I'm sorry, they say, stop making false statements. The professor filed a lawsuit. Yet even that has not been enough, as TikToker has continued to post false statements about the professor, even while this litigation has been pending. We've covered this. We've gone through the procedural background. I don't think we need to go through the applicable law. Punitive damages are the issue at trial. The issue at trial is how much in damages, including punitive damages. And then the evidence that will come in is witnesses. The professor intends to introduce exhibits with her personal information about her healthcare treatment, which includes information about her children, her home address, and other personal identifying information. The professor has asked the court to enter a protective order protecting that information and anticipates asking the court to redact it from the public record from the portions of those exhibits. And we'll have a separate motion in limine addressing anticipated evidentiary issues. And that's it. That is the trial motion. And there has been no response. We have not seen a response. And I am very interested to see what we do from here, because this case raises a question that we have talked about in numerous cases and continue to talk about. What happens when, especially like this, it goes viral and you reach out to the person and are like, this is defamatory, stop. And the person's like, I don't care. And makes content out of it. What do you do? And sometimes suing to at least have that be covered is the only thing you can do. I feel tremendously bad for the professor. I do not tend to cover cases pre-arrest because at times the amount of hysteria around cases is not helpful. And I really do look at the things we talk about here as and my role in it, can I help? Can I help bring clarity, understanding, even if we don't like the way something is, even if we wish things were different, can I bring some understanding of the law is this way, or the things that are happening this way, or this is why something might be going slowly? Can I help explain, illuminate the law, and really provide some useful fact-based information? Oftentimes before we have lawsuits filed or arrests made, there is tons of speculation, but not a lot of facts. At least when we have facts or what lawyers are alleging are facts, we have some grounding to try to evaluate whether that seems sus or that seems accurate or whether we're going to get a process to figure it out. Because at least if there's a process, then we can evaluate the claims. If there's a defense and someone is saying A defamed B, if it goes to court, then we get to evaluate A defamed B. And if there's a whole lot of that doesn't seem right in the middle, then we can talk about it. But it's one of the reasons I don't cover a ton of things before there's a filing or a lawsuit, because it is so speculative and tenuous, and there is so much noise around people taking things that aren't even things and running with them. We just saw this in the Lively Baldoni case, and we have not touched on that in a minute because the lawyers have made this case their full-time job, and it is not my full-time job, and I have not kept up with it nearly enough because there are hundreds of filings. But months ago, the court dismissed Baldoni's counterclaim, and we knew that. And Baldoni's lawyer came out and said, yeah, we're not going to refile it. We'll just litigate her complaint. And then all of a sudden, all these headlines popped up with, Baldoni loses in court and this, and that. And I'm like, first, that happened months ago. Second, that's not even accurate. Third, what? And fourth, his lawyer said, we're not pursuing it. We'll just pursue it through her cause of action. We're choosing not to go forward with it. And I'm like, well, right. We talked about that months ago. This isn't new, and this isn't even accurate. This was a litigation strategic choice. Why is it being reported so weird? So there are times where I just nope out because it is so wild, but we see it with cases. We saw it with Depp Heard. Not only did the internet go wild while that case was in trial, but also we were watching legitimate media organizations report things that were happening on social media as if they were things happening in court. And I was floored. And I think my view of the media had changed some, but that forever changed my view of the media. And it's wild. But the type of fervor that was going on in Idaho when people were afraid is something that locally people need to deal with, because of course there was fear. Of course there was stress. Of course there was a desire to know what was going on. Of course people were upset. I can't imagine anybody not be. But then to spiral it into this person did this and this person did this and this person did that isn't helpful. It's not helpful at all. There are definitely times and places to raise questions, but whipping people into a fervor of fear that is not fact-based is not helpful. And so I always find that there's this balance between what is helpful and what is not helpful. And there are times where the internet is incredibly helpful. And we've seen that. I think the attention on the Karen Reed case has been incredibly helpful. Truly. I think when we were looking at the early days of Gabby Petito's disappearance, before we knew that it was a homicide, though I think from the beginning there was a lot of concern. When folks who had been through the area went and found footage and helped law enforcement, there is room to help. But if there's room to help, there was also those who will exploit and not care if it does harm or not. And so it can be a difficult balance. And I always try to keep an eye on that balance and be mindful of it, which is why I don't report on things that are rumor and that are speculation not grounded in fact. There are some facts here where we can be like, can we speculate this TikToker might not show up? I think we have a history here. I think we do. And I always try to balance that. So there are times that there are things I don't look at as early as others might. And that's just a personal choice on my end. Shockingly, this is going to surprise all of you, I really, really like the balance of knowing people will be heard in court. We don't always like the way court goes. I don't always agree with how judges handle things, but we know that there is an order and we know that people should have their opportunity to be heard. And so that process, even though sometimes it's slow and it's frustrating, is at least a process we can go through, which is what's so frustrating about the TikTok psychic case. The stories blew up before Kohberger's arrest. I don't think they've been retracted. I mean, even in Depp Heard, trying to get a retraction on some things was so incredibly arduous, and a lot of it hasn't been retracted. So even when you win in court, it's so far down the road that there's very few, and no one in more legacy media still covering this case, even though everybody covered it when the TikToks were going viral. So we're still covering it because I think it's A, important to do so, and B, it really highlights, what do? You go to work, you do your job, and a tragedy happens in the community where you work. And all of a sudden, somebody on the internet starts pointing fingers at you and it goes completely viral. And you're getting death threats on your voicemail at work. What do you do? And so I feel for the professor in this. It frustrates me to no end. I think it is horrendously irresponsible for people to make these allegations. And then if somebody tries to avoid having to pay for it, what do? So I think the professor is doing the only thing that they can do. And I feel like the least we can do is keep an eye on it and talk about what happens and say, this story still matters. This story is important. And this professor's been vindicated. But Google remembers. Maybe we will get to a day where if you win, you can start having Google take some of these stories down. Maybe. But I don't know how you do that. So we'll see. We'll see. Is this going to go to trial? I don't know. It might. It might not. Do I think the TikToker is going to show up? I don't know. I will be more surprised if the TikToker shows up. That's where my level of surprise will be. I will be surprised if they show up. Maybe they will. Maybe they won't. Some of you are asking, like, are we going to get a Baldoni Lively update? When I can get caught up, yes. When I can get caught up, yes, we will get an update. I have not abandoned it. It's just really hard because it has sprouted like tentacles. It is hard to follow where the groundedness is. And the judge was already pissed months ago when the judge was like, stop using filings as press releases. So yes, I will. It's just going to take a minute, but is that case really going to go to trial in March? I don't know. I don't know if it will. We'll see. But yes, it's on my radar, and we will absolutely cover it in bits of this is what the court is saying. I think what I will try to do is gather the court orders, but then I need to read all the motions so I have enough background to be helpful to summarize. So we'll be doing it in summaries in the podcast as we can. Right now, we are getting ready to go to BravoCon, so I need to get going. Lunch Lady, I was thinking about covering this tomorrow. So we will see. I was thinking about covering this tomorrow. So we'll see. I have not decided what we're covering tomorrow. And every time I plan early, something else fucking pops off. But I just want to, like, bravo, fucking bravo. Tomorrow, I will be shifting our time because I have appointments that are going to square right into our stream time. I might stream earlier. I know. I will let you know in the Law Nerd app when I'm going to stream. We will be streaming tomorrow. I might stream earlier so then I can just like allow my travel stress to like do its thing in the afternoon. But I do have an appointment that I have to get to. Tara Michelle, thank you so much. Tara in the chat said, I appreciate your integrity and ethics. We don't see much of it in the media anymore. Look, I just cover things the way I would do it if I was talking to my friends. So I want to have the information. I want to know. I don't mind if other people speculate. I'll listen to what they have to say, but I'm not going to be the one putting it out there unless it's grounded. I'm also very much a grounded person. It's what makes me the most comfortable. Also, there's enough drama. I have teens. I have teens and I have very sassy orange cats. Like, I don't need any more drama. I am like all earth signs. I don't want the drama. I'll occasionally watch someone else's drama and be like, the drama is dramaing. I don't want it. I don't want to deal with it. I don't like it. I don't like any of it. Nope. Court's dramatic enough, y'all. We don't need to make shit up. It fucking happens. We don't need to make it up. Court's wild. We just get to wait for it all to unfold and then talk about the law. That's all. It's drama enough. The lawyers are so dramatic. So it's law. But make it gossip. And then we'll talk about a bit of Bravo. Because you know what happens every time I go to BravoCon? It's more the husbands than the housewives themselves. Everybody wants everybody else's tea. So I got to make sure I'm up to date on all the stuff going on in the Bravo world. Because it's always the husbands that are like, hey, what's going on with this? And I'm like, girl, let me tell you what. Because they all want to know. They all want to know. Law nerds, have a wonderful, wonderful day. Oh, Becky, don't worry. Well, we're going to keep an eye on Ron. I don't think we have anything new. He's supposed to go to court in December. So I don't know if there's anything more, but we'll see. So the husbands are so much fun to talk to. True. The husbands are so much fun to talk to. Also, there is so much else going on. Most of the Bravo Lebs do not really have time to just chat, but the people with them do. So we'll take a look at what's tomorrow. Stay tuned in the Law Nerd app at lawnerd.app.com because I'll let you know what time we're streaming. I have not decided yet. Truly, the mods are like, when are we streaming? I have to look at my schedule for tomorrow and how much packing I have to do, and I'll let you know. Law Nerds, you're the best. Get the Law Nerd app. We built it for free. Well, not free for us. We built it for free for you on iOS and Android. I know you love it. Join the over 100,000 Law Nerds that are in the Law Nerd app, and I will see you guys tomorrow. Same channel. We'll see what time. I'll let you know today. All right. Bye, Law Nerds. Thank you, mods. See you guys tomorrow. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerd.app.com. It's a free download on iOS and Android so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here and thanks for being a Law Nerd.